Good morning. Happy Thursday. Welcome to the Courtroom Files Live. We will start our day with Judge Simpson.
9 a.m.
Thank you, Judge.
Bond will continue. Do I have the form?
I have it here, Judge. I apologize. I will send the Zoom link.
Or you want us to wait for you to fill it out?
Absolutely not, Judge.
All right, you have it?
Trying to get it
Where,
right.
what? No. Geez. Court calls the case People versus Jason Burkett.
Jennifer Douglas for the people.
Morning, Judge.
Good morning.
To see you. Christina Costantino appearing not with, but on behalf of Mr. Jason Burkett. Mr. Burkett, can you please state your name for the record?
Jason Matthew Burkett.
Judge, I am at this time asking for an adjournment of this matter. I was actually not made aware that Mr. Burkett was in custody prior to today.
Okay.
It makes sense why I wasn't able to get in touch with him over the phone now.
Got it. Is he in custody on this case or something? Okay.
Last night, somebody freaking.
He's in on something else.
On something else, Judge, yes. Do you know what your bond is on this case?
Outstanding warrants. He was arrested on.
Okay, sir, turn around.
I
So is he, I don't know what he's being held on because he's not held on this case.
I don't know either, Judge.
don't know what I'm
Did you
talking
get a
about.
new charge?
I don't know what they took me on last
Have you
night.
been in front of a judge?
They picked me up
Judge,
last
at this
night,
time, we're unsure why he's presently in custody.
Okay. Right, I will adjourn this out June 5th.
or not, just- it was last night.
Oh, Your Honor, he's got a new warrant that was just authorized. So apparently that's what it is. Although he did have an outstanding warrant.
It was just out, is it in our system or, I mean, because I'm gonna adjourn this out and then. Today?
That's what
Find out, I mean, it's not gonna make any sense if I put this out to. But we don't have a case, I don't know how you'd be on our arraignment, we don't have a case in JIS.
Right, stand property.
Okay.
Try to get you out of the first.
So I'm actually for two different things. One is that we are in the process of charging it, but also he's on the arraignment list, so I'm not sure.
I'll adjourn this case to the 5th at 9. It's bond in this case, I guess, will continue. Unless you want me to give him a nominal bond on this case, because he's got a PR on this case.
Judge, it's a little bit difficult for me, not even knowing what the charges are that they're contemplating potentially authorizing. So
Let's maybe
I'd-
find it out. What are the other charges?
I'm trying to remember. I better read.
That was all from this guy. Oh, this one was Jeanette.
And Judge, just to complicate things even more, I'm not
No,
available
you did this
on the
last week.
5th.
You did it, what?
No, I'm not available on the 5th.
I know, you told me that before, and I know when I was setting the date, I said, she's not gonna be.
I know, I'm sorry.
All right, go ahead.
Entering a vehicle to steal property.
Okay.
Is that being charged as a misdemeanor? A misdemeanor. Judge, given the new charges of misdemeanor, I would ask that you continue the personal bond in this case.
All right, I'll continue the personal bond. I'll adjourn this to the 12th. Then 9 a.m. He is on the list. can you, is it a felony ring?
You're gonna have to read this
Today?
later today.
Bond violation.
I'm gonna ask for a person.
I was sent. I can go on whatever.
Okay.
What do you mean? Before you send it. Yeah. Send it, no, from here. So he's on the docket this afternoon for a bond violation.
So I'm told there's a potential new case, but they haven't.
And would that be a bond violation in my case?
Well, it would have to be only because, because we don't have any other case. So tell them after the arraignment on the bond violation to set it for to get to the magistrate's office to set him for the 12th.
Yes.
So that we get that case together.
Yes.
All right. So I'll put it for the 12th. At this point, his bond will continue. Thank you.
Thank you, Judge.
Thank you.
Calls the case, people versus Zachariah Karuska Dennis.
I'm back for more, Judge.
Oh, no.
I brought in the big guns here with me, though.
Lauren?
Yeah. Yep.
That laugh. That's the only kind of gun you can get. That's fine.
Good morning, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Zachariah Karuska Dennis. Could you state your name for the record?
Zachariah Karuska Dennis, Your Honor.
Thank you.
And Judge Christina Costantino appearing on behalf of the defendant in case number ending in 1150.
Yes.
With
All right.
5076.
What are we doing? You're on the other matter, Mr. Brown.
Your Honor, currently we have a mitigation report that is pending. The mitigation office AIM has just requested a report. They have not received that yet. Once they receive it, they'll be able to finish the report and we'll be able to present that to the prosecution to see how we can resolve this case. However, that will take, we expect about 3 weeks to be able to get all of that done.
3 weeks to get it to them?
To get the report has to be finished. Have to first receive the information they requested, write the report. We have to review it and then send it to them. Then the prosecution has to read it and make a decision.
Very quick reader, Your Honor.
All right, good.
Does Evelyn?
So if I set this for the 12th, or you,
I think
Yes.
the 12th is good.
that work?
12 was excellent.
Probable cause, thank you. Picked it myself. June 12th, 2025, 9 a.m.
Thank you.
Thank you, Your Honor.
Thank you.
So good morning once again, everybody. Welcome to the Courtroom Files Live. Happy Thursday. Kazman, if you are out there, I just tested the member's email. It seems to be working fine in both directions, so I have re-emailed you. If for some reason you don't see what I sent you, please check your Google spam folder because Gmail gets weird. It shouldn't go there on a reply, but they get weird. Anyways, let's go back to Judge.
That's called the case of the people versus Desmond Burton.
Assistant Public Defender Chelsea Vergils with and on behalf of Desmond Burton, who approaches. Mr. Burton, please state your name.
Desmond Burton. Thank you.
Your Honor, we're asking to set this for a preliminary exam.
All your discoveries complete?
Yes, Your Honor, I believe we have all the discovery that exists.
All right. People have their witnesses available. June 3rd.
I will not be available. Going to the training.
So that you got other attorneys. Will the people have their witnesses available on the 3rd?
Yes, we can go to that.
Preliminary examination, June 3rd, 2025, 9 a.m. That is before Judge Perry.
Thank you, Your Honor.
And we'll continue.
Thank you, Your Honor.
Court calls the case people versus Kenia Jackson.
Jennifer Douglas for the people?
Jim Mack appearing half, Ms. Jackson. Your Honor, may we have
Your name?
Kania Jackson.
Thank you.
Your Honor, may we have a very brief conference at the bench?
Why not? Everybody else has. Come on.
All right. Well, they have their very brief conference at the bench. Let's go say good morning to Judge McNally.
I ordered you to pay $235. You were supposed to pay this then, weren't you?
No, I already paid it. Oh, I got the receipt if you want to see it.
When did you pay it?
Today. The online.
You were supposed to, hang on, slow down. You were supposed to pay it on February 27. I wrote pay now.
It didn't let me pay. I tried it with the lady. It didn't let me pay. I tried to pay online and it didn't let me.
On February 27?
Yeah, because I had tapped to pay, so she told me to pay online. So, yeah.
I don't know. Did he pay it today, Lisa?
Yeah, he paid 100 on February 28th, and then he paid the balance today.
I'll tell you what, just next time, don't ignore me like that, okay?
Yes, sir.
All right? All you gotta do is come in and talk to me. It's not that hard. If they told you you couldn't pay down there and you had to pay online, you couldn't pay online, you gotta come talk to me, okay? I'm gonna go ahead and dismiss this. I'll just let it go, okay?
Judge, this is also set for prosecutor review.
So now you gotta go talk to the prosecutor in Gibraltar and she can move to dismiss, assuming everything is in order. Let me see. John, this needs to go over to Jessica. She can make notes. Actually, it looks like all I did was fine you. So she still should write it down so the prosecutor knows, defendant compliant, and then you can take it over to Ms. Zelnick. Just bear with us, and we'll get you out of here soon, okay?
Yes, sir.
You're all set. You can go out in the hallway.
She's gonna give us to her. She's gonna do what?
Take it to Jessica.
Yeah.
Just have to make a note that she's compliant.
Oh.
He's compliant, and then take it to Ms. Zelnick. Come on up here, Mr. Harrow. John Craig Harrow, 25G306-449. A and B. All right, Mr. Harrow, your name.
John Harrow.
Should have been a lawyer. You got a good deal here, right? You're gonna plead to allowing the licensed driver to drive. They're going to dismiss. She wrote drive while license expired, but she didn't dismiss the other case. This is with Gibraltar, right?
Yes. She said she was gonna dismiss the case.
Maybe she just got confused with drive while license expired versus expired plate. I'm gonna have to send this to her back, okay? Where's she at? Is she in 249, do you know, Lisa?
Right here.
She's right in here? Can you send Ms. Zelnick in here, please?
Yes, sir.
Thanks. All right, so you have two charges. You've got driver license expired. She's pleading that down to allowing an unlicensed driver to drive. She's going to let you do that, and then she's going to go ahead and dismiss, according to you, expired plate, but I'm going to double check with you. Ms. Zelnick, your name? How are you? Good. Were you going to dismiss the expired plate?
Yes, Your Honor.
Okay, you just need to add that on there. No problem.
Thank you so much.
So then it's going to be, the other charge will be dismissed. If you plead to allowing an unlicensed driver to drive, the possible penalties are up to 500 fines, 90 days jail, costs, or all of those. Do you understand that?
Right.
And did you sign, read, and understand an advice of rights form here today?
Okay.
If you plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
Yes, sir.
All right. You still wish to waive your right to a lawyer? To the charge allowing an unlicensed driver to drive, how do you plead? Were you in control of a motor vehicle on April 18, 25, a 2012 Jeep that was being operated on Old Fort near Gibraltar, in Gibraltar?
Yes.
And were you unlicensed?
Yes, sir.
Are you on probation and parole?
No.
Anybody force you to plead guilty?
No.
All right, I'll accept your plea to that charge. Dismiss the drive while license expired. Dismiss the expired plate pursuant to agreement. Is there anything you'd like to tell me before you are sentenced, sir?
Yeah, Your Honor, I was just going through a hard time with work. They weren't paying me. And
Who do you work for?
I work for A&M Automotive, and we were trying to open up a business over here, it's 5522 West Jefferson, and they were jumping through hoops with the city of Trenton. So the pay got like shorter and shorter, then I wasn't being paid. And at the time I had a screenshot of the Secretary of State appointment. My birthday was in March, so I had it in March, I believe. And it was April 2nd. When my Secretary of State date came up, I had no money to take care of it. So I made another appointment for the 23rd, and then I was pulled over right before that. But on that same day, I got a new job with Elite Car Care and Taylor. And I didn't drive from record and everything. I just didn't have the funds to take care of it at the moment.
Okay. That's fair. You saved yourself a couple bucks. 50 fines, 50 costs, 75 victim charge, $50 justice assessment, 2 1/4 or 30 days. You can go down and take care of that. You're all set.
Can I take care of it Monday and Saturday?
Yeah. Do you need, can you pay it all on Monday?
What's the total?
$225.
I didn't pay that.
Well, we're not open Monday, so I'm gonna give you till Tuesday, okay? Monday is Memorial Day, so maybe 27th. Okay? If something happens, you need more time, no problem. Come talk to me on or.
Can I pay that online?
Yeah.
Okay.
And there's no fee as long as you're paying it in full.
We got me coming in at 7:45 for work.
Good.
All right.
We're there. Good luck.
Thank you.
Wasn't too painful. All right. Rise of Gibraltar LLC. 25G82794. Do I have some? Is this case counts, Jennifer or Lisa?
They're here for that case, but I have not put them in the breakout room yet.
Oh. Do you have an appearance from them?
Oh, no, that's what the issue is. There's no appearance on file.
I gotta have an appearance from you, counsel.
Can I put my appearance in just on the record here?
No, you gotta email an appearance form over to the judicial clerk. I can't call your case until I have a written appearance.
All right, what's the clerk's email? I can put that.
Lisa?
It's Lisa at 33court.com.
And we'll take that one back to Ms. Zelnick. So. So that one's going to them. This one's going down the hall. Republic Services, who's this? 25T645-483A and B. Serbo? Good morning, counsel. Your appearance?
Good morning, Your Honor. Matthew Wood, P74329 on behalf of Republic Services.
And are you with Mr. Sherbo's firm?
I am, yes.
What do you have to do here? You have to...
If Your Honor, I had a chance to speak with the issuing officer and the prosecutor this morning. We're asking for an adjournment so that we can look into the bridge itself that the underlying ticket is completely based on as far as what the weights are. The issuing officer wasn't here today, but his supervisor was. So we're just asking for an adjournment.
I'm gonna give you a couple of weeks, but that's it, okay?
Understood, Your Honor.
What do you have, Lisa, for me? This is Trenton.
June 9th at 2 o'clock.
June 9th at 2 p.m.
Thank you, Your Honor.
Okay, we'll see you back here then, and have a good day. Thank you.
You too. Bye, Your Honor.
All right, let's change it up and go to Florida. This is Judge Wade Mercer, I believe. Yes, Wade Mercer.
County probation and probation case number 25-134 that has no bond on it. In addition to that, Mr. Jenkins, you have 2 new charges. You're accused of 1 count of possession of controlled substance and 1 count of possession of drug paraphernalia. There is probable cause for both of those charges. I'm going to set you a bond in those cases. But Mr. Jenkins, understand there's no point in posting a bond because you wouldn't get out anyway because I'm holding you with no bond on the violation of county probation. So your bond in the third-degree felony possession controlled substance is going to be $10,000. Your bond in the paraphernalia is going to be $5,000. It'll have a condition of random urinalysis on it. That means if you ever do post bond at some point in the future, you would have random urinalysis. But again, you've got no bond in the violation of county probation case at this point. And I think I told you already, but your mother's in the courtroom. Mr. Jenkins, do you have any questions?
No, sir.
Ma'am, do you have any questions? All right, wish you the best, sir. And I need to take this case.
Miss Hill.
Alexandra Hill.
Yes.
Alexandra Hill. And do you want her to know that you're here? What's your relationship? Okay. Ms. Hill, your parents are in the courtroom. Ms. Hill, you're here because you've been accused of one count of resisting an officer without violence. Ms. Hill, I've read the complaint. There is probable cause for the charge, Ms. Hill, but the complaint also says that this call originally started as a Baker Act. Well, I don't know if that's how it started, but at some point there was a Baker Act allegations made. I think the officer even felt that you met the requirements for Baker Act, and he may have even filled out a Baker Act. Give me a second to double check that. Mr. McDaniel, is that right?
That's correct. He did, and she's going to go to the Baker facility this morning.
I don't know that I've ever seen that where, you know, where they do both arrest and Baker Act, but
they normally always do both. A lot of times they just don't always give us the paperwork. A lot of times
they don't,
just
and maybe that's the difference. I've never seen the paper. That makes sense. So,
yeah.
So Ms. Hill, I think that you have no prior history. Is that right, ma'am?
Yes, sir.
Okay. So Ms. Hill, I think the primary concern I have, and I'll listen to the attorneys before I make a final decision. My primary concern is this appears to be perhaps some mental health needs that need to be addressed more so than the criminal allegations, which are serious, but nonetheless, this is not another type of crime where you had a Baker Act concerns. It was primarily a Baker Act call. So let me listen to Mr. McDaniel and Mr. Mitchell, and then we'll see where we go from here. Mr. McDaniel.
Your Honor, we just asked for maybe an ROR or conditional release and just let her, you know, go ahead. She needs to go up to the Baker facility and see him. You know, she's just having some issues and, you know, it's affecting her mental health and, you know, it's not a risk of anything except for maybe to herself, you know, and we just asked the court to let her go ahead and go on to the Baker facility.
Mr. Mitchell, anything from the state?
We have no objection to an ROR conditional release. We do request that she be placed on the June 30th arraignment docket. I believe I should be able to resolve this well before then.
So, Corporal, I have a question for you then. When the officer does the Baker Act but doesn't take her at that time, is it still valid the next morning, or do you have to do another evaluation? Can you just send her with that evaluation from yesterday?
48 hours. 48 hours.
So it's still valid, correct?
Yes, correct.
Okay. Does the family have any questions or anything else we need to know? Are you familiar with the Baker Act process?
She's actually on disability for mental health reasons due to its traumatic brain injury. So we just wanted to ensure that the Baker Act was going to take place.
That's what you're asking for too then. Sound like everybody's in agreement then? What I'm going to do, Ms. Hill, is I'm going to give you a ROR, which means I'm going to release you on this charge, ma'am. And the only conditions are going to be, well, actually, the only conditions will be no new law violations and to show up for your court date. I'm going to ask the jail to give you a notice for that court date. And that would be June the 30th, the next June the 30th at 9 a.m. They'll give you that written notice before you leave the jail, and you'll be taken to one of the appropriate hospitals, ma'am, for the medical evaluation, and that'll happen sometime today. Ms. Hill, do you have any questions?
No, sir.
Family have any questions? Yes. They have to do the transport. Yes. All right. Wish you the best. Thank y'all for coming. And the jail can tell you when and where. There's a couple of facilities. They've got to take them in a certain order. If one's full, then there's a backup facility and so forth. But the jail or the sheriff's department, if they're in custody of the sheriff's department, Corporal, does the jail do the transport or does the sheriff's department do the transport?
Sheriff's office.
Sheriff's office will do the transport.
So the sheriff's department would be the one to tell you which facility she's going to. Okay. Yeah, I'd contact them this morning and ask them. It should happen this morning. Okay. You're welcome.
So, since they referenced Baker Act, in case anybody doesn't know what that is, its official name is the Florida Mental Health Act of 1971. Specifically, it is a law that allows for the involuntary commitment of an individual who might be having mental health issues. So that's what they were talking about. Back to Judge.
You have a warrant out of Bay County. I looked at the teletype from that county, Mr. Ramirez, and it just says it's a VOP with no bond. So what that means is they're going to be held with no bond until you can get to Bay County, Mr. Ramirez. That should happen. Today is Thursday. It could happen this week. It also could be the first of next week. But when you get to Bay County, you'll go to another first appearance in front of a local judge, and that local judge will address your bond status. But right now, they're telling us that you have no bond. Do you have any questions, Mr. Ramirez?
Yes, sir. The warrant, it doesn't specify what the warrant is for. It doesn't say violation of probation or anything. It just says a warrant.
No, I think I just said that. It says violation of probation, petty theft, third conviction, hold without bond. Are you asking what? Are you asking what the violation itself is based on?
Yes, sir, I am.
Okay, I might can answer that question. Give me a second to try to look up the file in Bay County system, and I might be able to tell you what specifically you've been accused of and how you supposedly have violated your probation.
Because I didn't abscond. I was just having a problem with the Chrome Ministries, and they asked me to come back on the 27th. So I didn't ever leave Chrome Ministries.
The allegation is that, well, the allegation is kind of lengthy. It says the offender was ordered to complete the Chrome Ministry program, arrived on the facility on December 30th of 2025. On May 7th, it was advised to this officer that the offender was released from the program due to rule breaking. According to the dismissal letter sent from the facility, it's a typo there, it had received a program extension for threatening to do bodily harm to the clients in March. It was confirmed that he had threatened to beat a client, and then it goes on to say, so essentially, you're accused of not successfully completing the program. That's the basis for the violation.
Right,
Any
but
other
I
questions?
I got a recording from them asking me to come back and talk to them on the 27th about coming back to the program. So how does that it contradicts each other?
Not necessarily. Just because you're kicked out doesn't mean they won't accept you back. But you're accused of not completing the program. That's why you got to go to Bay County. Any other questions?
No, sir. Have a good day.
Have a good day, sir. DeQuan Williams. Mr. Williams, good morning. Mr. Williams, you're here for first appearance accused of one count of driving with no valid driver's license and one count of obstructing and resisting an officer without violence. Mr. Williams, there is probable cause for these charges, sir. I'm going to appoint the public defender's officer to represent you and ask that you listen to Mr. McDaniel, your attorney.
Your Honor, I spoke with Mr. Williams, and at this point in time, he's going to have no contest to the charges as listed. The understanding, he'll be sentenced to 60 days in county jail, 1 day jail credit, $400 fine, withhold or adjudicate guilty, and he has signed his plea waiver form, waives right to jury trial and call witnesses.
Thank you. Do you have any those clips? The jail uses the paper clips when it's about 3 times too thick. So I've replaced his paper clips about 4 times this morning and they keep popping off. I'm sorry. Yeah.
And that is agreeable with the state, Your Honor.
Okay. Mr. Williams, give me just a second. I'm having to redo this paperwork again because it's just not set. This one here is paper clips are bent and it. All right. So Mr. Williams, did you hear that agreement, sir?
Yes, sir.
Mr. Williams, do you have any questions about that agreement?
No, sir.
Mr. Williams, is that the plea that you would like to enter?
Yes, sir.
Mr. Williams, I'm going to accept your plea of no contest, sir, to the charge of driving with no valid driver's license and resisting an officer without violence. I'm going to adjudicate you guilty of those offenses, sentence you to 60 days in jail on each case concurrently, Mr. Williams. That means running at the same time. I'm going to impose the standard court costs and fines of $400 in count 1, waive the court costs and fines in count 2. Mr. Williams, hopefully you'll get you some extra game time, sir, and get out of there a little early. There's no probation involved in this sentence. Mr. Williams, do you have any questions?
No, sir.
Have a good day, sir. Daniel Oswald. Oswald, good morning. Mr. Oswald, you're here because you've been accused of 2 counts of resisting an officer without violence, Mr. Oswald, and you're also already on bond. It looks like in 24-119 CF. I think that's correct. My handwriting's not great. Is it 24-119? Is that what you're showing?
It is.
Mr. Oswald, there is probable cause in the new charge. I'm going to appoint the public defender's officer to represent you in that case, sir, and ask that you listen to Mr. McDaniel, your attorney.
Your Honor, Mr. Oswald is going to plead of no contest, resist without violence. Understanding he'll be sentenced to 6 months in the county jail. He have a 1-day jail credit. He has signed his plea waiver form, waiving his right to a jury trial and call witnesses.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor. And do you need a proposed order this or today?
I do, because I'm going to revoke his bond in case 24-119 CF. If you give me an order revoking his bond in that case, please.
You'll have it today.
Thank you. Mr. Oswald, did you hear that a plea agreement, sir?
Yes, sir.
Mr. Oswald, any questions about that agreement?
No, sir.
So, Mr. Oswald, this will let you finish this out. This will be over with, hopefully, by the time you deal with your other case. Hopefully you'll get that case. That case has been hanging around a while, so maybe you can get it over with.
Okay, yes, sir,
case.
yes.
So, Mr. Oswald, this is what you want to do, correct?
Yes.
Mr. Oswald, I'm going to accept your plea of no contest. In the misdemeanor cases, resisting without violence, 2 counts. The judge who guilty of those offenses, Mr. Oswald, sentenced you to 6 months in jail on each case concurrent, running at the same time, 370 court costs and fines, 1-day credit for time served. I have no problem with you participating in the trustee program. Hopefully you can do that, Mr. Oswald, and get you some extra gain time. I'm going to ask Mr. McDaniel's office to notify your attorney in the felony of the status of that, because the attorney needs to know that you're in jail with no bond, so the attorney can come see you at the jail. Mr. Oswald, do you have any questions?
No, sir.
Sir, I wish you the best.
All right, thank you.
Yes, sir. After.
All right, let's go back to Judge Simpson's court, where Miss Jones continues to apparently hate her life.
Couch.
Your Honor, this is a co-defendant to Mr. Bernstein's case a few minutes ago.
June 12th.
June 12th, yes, Your Honor.
Probable cause conference, June 12th, 2025, 9 a.m. Bond continued.
There is one thing I'd like to address as far as the bond is concerned, Your Honor, and this is a very unusual situation. Mr. Couch, when he was arraigned by the magistrate set the standard conditions, among them being no contact with co-defendants. One of the co-defendants in this case is my client's wife, which creates several problems. One of which is that they run a business together, which they can't do if they can't have any communication. The other is that Mr. Couch has some significant medical problems. She is usually his advocate, takes him to doctor's appointments and so forth. So we're asking if the court would consider dropping that provision. I know she's going to have to address it when she's before the court next week. But as far as my client is concerned, we're asking if the court would drop the no contact provision, specifically as to his wife, not the other defendants.
I would ask that no contact order. This is a pretty significant case involving breaking into a home, zip tying up individuals, using a chainsaw to access portions of the house looking for money. There was the possible use of firearms. So the defendants are all charged with armed robbery, unlawful imprisonment, so on and so forth. It does appear, based on the investigation by the state police, obviously a plan and concerted effort by these individuals. I would ask, I know it is unusual to have husband and wife charged as co-defendants, but I would ask that no contact will remain in effect at least this month.
Very briefly, Your Honor, the arguments that Mr. Childers made really go more to the issue of what the bond should be in terms of dangerousness, et cetera. The magistrate considered those.
They were acting in conspiracy with each other, doing it. You would want to keep those people separated.
I wouldn't, Your Honor, but the court might. I appreciate that.
I'm saying you in the general sense of those that rationally think it through. I'm going to deny the bond request. I'm going to have his bond continued till I can maybe take a look at the other case and that I don't have before me that's set for next week.
Yeah, she's set for next week. I'm assuming hers will get kicked over to the 12th also.
12th, correct. Who is their counsel?
Hers?
Yes.
I don't know, Your Honor. It's not public defender because they have another person that's up today. Is the other one up today?
Yes. It's not the public defender's office. I don't know whether she retained her own attorney or
What's her name?
Christie?
last name, Couch.
Couch. Chris.
I know she
How
was
do you spell Christie?
Kristi. I know she was going to talk to Jeff Osmond in Monroe, but I don't know if she's actually ever done that or not. I spoke to him briefly last week and he said he might be representing her, but
Okay, so she's been arraigned.
she's been arraigned. She was arraigned the same day as Myron was, Your Honor.
She was arraigned. My understanding is the judge or the magistrate gave her a PR or a substantially lower bond, and for that reason gave her more time. I think at the request of the PD at the time of arraignment, set a later PCC.
Right, but she would have been given counsel.
Your Honor, I was present at the arraignment. She indicated she was going to, I indicated for her because she had asked me to stand in at the arraignment. We indicated she was going to be hiring. And as I said, she mentioned a Jeff Osmond. I spoke to Mr. Osmond. He is familiar with the situation. I can contact him, make sure if he's going to represent her, he gets an appearance in before next.
Well, if he gets an appearance in and just a stip to adjourn, so they don't have to.
Okay, I can.
That's what I was trying to get at.
Okay, I can let him know that, Your Honor.
All right. Okay, thank you.
Thank you.
Court does call the case People versus Victor Morris Gerard.
Good morning again, Your Honor. Chris Eastup on behalf of and with Victor Morris Gerard, who is standing to my right.
Your name, sir?
Victor Morris Gerard.
Okay.
Your Honor, it's just going to be a waiver of the exam.
Waiver. Okay. And sir, you're waiving your right to have a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, I understand.
And you understand that you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on all three counts. Mr. Easto.
Waive formal reading, Your Honor. Stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
June 4th at 1:30 p.m. with Judge Conlon.
June 4th, 2025, 1:30, Judge Conlon.
Your Honor, may I address bond really quick?
You may.
Your Honor, my client was initially, when he was charged, he was given a PR bond or a low bond, and then he was ordered to test. He failed, unfortunately, a few tests because he was struggling with substance abuse. And then his bond was revoked. Then this court was nice enough to amend his bond to allow for to go to inpatient treatment. However, he hasn't financially, it's been a little difficult to reach that. He's not on Medicaid yet for Dawn Farm, so that he could only afford less than a month. So he hasn't been able to do that yet. So I'm wondering if the court would consider giving him a second chance on either like an alcohol tether, because alcohol is technically his bigger issue than it is narcotics. He struggles with alcoholism. So if the court would consider putting him on a scram tether or a different type of alcohol tether and putting him back on regular testing at community corrections, I think we do have a plea deal worked out that will be done up in the circuit court, and his guidelines are relatively low given this case. And I think he's spent over a month in custody already.
Right, but I think he really, I mean, part of the reason that we modified it last time is he really needs treatment.
I agree, Your Honor.
And
I would probably agree with that also.
Yeah, and I'm just hesitant to release him on the hope. I mean, I understand the insurance issue, but I
could we make it a condition that he attend outpatient treatment as well as testing and scram or something? He's willing to do any of that. It's just the finances right now, I think, are what's keeping him.
He'll be up before Judge Conlon in a couple of weeks. What I'm going to do is I'm going to deny your request, and I'll let Judge Conlon's case, let him take a look at that. So his bond will. Okay. And can council approach on that last matter?
All right, let's change it up for a second. Let's go to
Headquarters
the
in Baton
great
Rouge,
state of
Alabama.
Louisiana, where they are about to do a parole violation hearing.
If the jail staff, would you please introduce yourself for the record?
Staff Sergeant Danielle Plaisance.
Sergeant Plaisance, thank you. And Mr. Corney, would you please introduce yourself by stating your full name and DOC number for the record?
Byron Corner, 3895-711-574.
Reviewing your paperwork from your previous preliminary hearing, and it was determined at that hearing that you were not eligible for appointed counsel based on Supreme Court guidelines that you can read and write and understand the nature of this proceeding. That's your signature on that form up there?
Yes, sir.
All right, so based on Supreme Court guidelines, you're not going to be eligible. But we will go ahead and have the hearing since you understand. What I'm going to do is I'm going to read to you the violation that it's alleged that you have committed and ask you then to respond by saying you're guilty, guilty with a statement, not guilty, or not guilty with a statement. And the parole officer advises us that you violated your parole by violating condition number 4. You were booked on 10/27/24 by the Gonzales Police Department with domestic abuse battery and simple battery under Ascension docket number 634363. The charge of simple battery has been now processed, and the charge of domestic abuse battery has been amended to a lesser charge of disturbing the peace, and that you did plead guilty to that disturbing the peace charge and was sentenced to serve 90 days in the parish jail with special conditions. How do you plead to that?
Not guilty.
Not guilty?
Not guilty with the statement.
Not guilty with a statement. Okay. All right, Ms. Stapleton is assigned your case, and she's going to go a little deeper into that not guilty with a statement and go from there.
Okay, sir, I was reading the police report about the domestic violence. And that at that time, the wife was talking to him and she said that you hit her on the left eye with a closed fist. And the reason all of this started was because you went through her phone and found that she had talked to a man, another man. Want to tell me about that?
That's not true. That's not true at all. It was the opposite of way. I woke up one morning and my friend had called my phone and my wife has to go to work, and I was communicating with another female, and my wife kind of got, aggravated and, heated in a moment, and we got into an argument. That's not true. And I never put my hands on it. We were just in an argument.
Well, they found probable cause at the hearing, the preliminary hearing, that it was true based upon the police report and statements.
Yes, ma'am, they did find a probable cause to send me to the board, but the police report is not true. That's a lie.
Okay, let me ask you this. Did you attend the anger management, 10-week anger management at your own expense? Did you do what that was a condition?
I never got released to get involved with that. I stayed in jail the whole time because of the parole hold.
Oh, okay. All right, because I was wondering about that. You pled guilty, though. It says here the domestic battery was amended to a lesser charge of disturbing the peace, misdemeanor, and you pled to disturbing the peace.
Domestic violence. Domestic violence got thrown out completely because it was dropped. It was thrown out. Did not want to press charges. And simple battery was the charge that got dropped down to a disturbing the peace.
And you plead guilty.
To disturbing the peace.
Disturbing. Your wife is here, and I believe she wants to speak. Is that true? Would you like to speak?
Yes, ma'am.
Okay, you want to tell us what you have to say?
Oh, the first thing is the police report is a lie. I lied because I was trying to get back because I felt like he was cheating on me and I was mad. So I felt like if you want to play with my heart, I wanted to play with your freedom at the time. The police did get called because my grandmother likes a quiet house and it had a lot of noise in their house.
What about the biting?
My uncle has a medical condition where he bites on himself. He has mental problems. The doctors are still trying to figure out like why he does that.
So when the police saw that, they thought your husband got into a physical altercation with him and bit him.
Yeah. And he didn't.
Would it try to step in and break up the fight between you and your husband?
Excuse, I didn't hear you. I'm sorry.
Did he try? Was he the man that stepped in between you and your husband to break up the fight? And that was one of the things that caused all the, I guess, noise in the house.
Yes, ma'am. But there was no physical altercation at all. It was a lot of screaming and yelling.
Somebody taken to the hospital?
No, he didn't go.
I'm just going to tell you this for your own information, because actually we have this often that even the police will see physical injuries on a person, and then they will can't, and they will tell the DA they lied. That's not unusual. And then in a domestic violence situation. So just in case you were telling the truth that night and you felt like you had to recant because it got him into a lot of trouble, I'm just going to tell you that if you would ever want to, there's some numbers that you can call and speak to people confidentially. It's the National Domestic Violence Coalition. And then Louisiana has the Coalition Against Domestic Violence. You can Google the number, you can call there, and you will have somebody to talk to that's probably been through the same things, and everything you say will be confidential. And it's a good resource that you can go to, just in case everything you said was really true. So that's all.
Okay.
Anybody have any questions?
Mr. Prater, you got any questions?
No, sir, I don't have any questions. I'm just, no.
Guess we're ready to vote. Ms. Stapleton, you're the first vote.
Mr. Carney, I'm gonna revoke you today, and you did plead guilty to the disturbing the peace charge, and you were charged with the other things that they found probable cause for, which was domestic abuse. So, but you did plead guilty to the disturbing the case.
Sheriff Prater, Mr. Prater?
I concur. Parole is a privilege that you get after you've screwed up, and you're supposed to abide by the law completely and avoid the appearance of impropriety. And it's apparent that you're not willing to do that. My vote is to revoke also.
And I'll concur for the same reasons documented by Stapleton. So, Mr. Carney, today your parole has been revoked. And this concludes our business at the Ascension Parish Jail.
get credit for being in jail on parole? No.
All right, well, it looks like they're done with him. So let's go back to Judge Simpson's court, where a interesting thing has happened. If we look at Miss Jones, she's in her bathroom now.
Weeks to make sure that evaluation is complete. All right, has the process started yet, or? According to Mr. Gaddy's notes, I'm not clear, but
I'm in CMH, so yes.
yes, it has started.
I think yes.
Okay. Well, I'm not certain. My client thinks that she is because she's part of CMH, but that's not here in Washington. All right, why don't we do this?
It's wash up email.
Okay. All right. Why don't I go 3 weeks instead of 2 and make sure. Probable cause conference June 12th. So we have 2025, 9 a.m. That bond continued. That was the 12th, Your Honor, June 12th. Okay. I'm going to give you a note. So you don't have to. All right.
I can put anything in there.
No. Okay. I'm going to give you this note. I'll have it. I'll bring it to you. All right. Then I can do that. Court does call the case of the People versus Chad Jones.
I never said good morning. Good morning, Your Honor. Kadma Dadish on behalf of Mr. Jones.
All right.
Please state your name
Good morning.
correctly, please.
Chad Jones. Thank you. All right.
Your Honor, I had not previously had client with Mr. Jones. He got into custody yesterday. I did speak to him with this morning, but we are gonna ask for an adjournment, please, so we can go over discovery and talk to the prosecutor about any potential offers.
And also deal with his violation report.
Yes.
All right. Probable cause conference in these matters, June 5th, 2025, 9 a.m. Bond will continue in these cases.
Thank you, Your Honor.
Thank you. All right. Yes. Second ruling and Mr. Childers, court's going to stand in brief recess. Take it back and talk about this. All right.
I can see it. All right, well, he's in recess. Let's go back to Judge Mercer in Florida.
Jail Officer Coleman, I can help you.
Hey, Officer Coleman, this is Judge Mercer. We're trying to do those first appearances by phone because the internet's down apparently.
Yes, sir. All right. I have them both here. This Carpenter refused first appearance this morning. He's under the influence.
Okay, well, let me take Vernon Webb first because that's who I've got first on my list.
Yes.
Okay.
Yes, sir.
Mr. Webb, good morning. Mr. Webb, this is Wade Mercer, the county judge in Jackson County, doing first appearances remotely. There's some technical issues, so the video system's not working today. We have on this same system, you could Assistant Public Defender, Mr. John McDaniel, is here on your behalf today. We also have the prosecutor, Mr. Mitchell, who's the first appearance prosecutor today. You're accused of violating the terms of your probation or community control. The allegation against you is that you were not at your approved residence and that was a violation of your community control. So, Mr. Webb, what I'm going to do is I'm going to put a 10-day hold on you. What that means is I'm going to ask Mr. Mitchell to notify the probation office that they need to submit a warrant to the appropriate judge and let that judge review it. That judge will then be the person to decide if you get a bond or not, if they're going to issue a warrant, and if there's a bond or not. But at least for 10 days, you have no bond. Mr. Webb, do you have any questions?
No, sir.
Wish you the best, sir.
Thank you.
Yes, sir. And Madam Jailer, we have Zachary Carpenter next, but he's not capable of doing first appearance. Is that right?
No, sir. Yeah, he's refused this morning as well as him being under the influence.
Okay. If y'all can if you can reset it.
All right, well, if they're having technical issues, let's stay in the 14th Judicial, but we'll go to different judge. This is Brantley Clark? Yeah, Judge Brantley Clark.
Maybe set it for the 24th?
Yeah.
All right, July 24th at 9 o'clock.
Thank you, Your Honor. That will conclude my business today.
Yes, sir. Have a good day. Ms. Anderson? Morning.
I have one case on today's docket. Mr. Espinoza. Mr. Espinoza, come on down. And Judge, that case number is 25-389. And Your Honor, Mr. Espinoza, his bond has been revoked. He's got a new charge that resulted in the revocation of his bond. We've been provided a misdemeanor plea offer. Lee Scott is on his new case, and I believe there's an arraignment set in June. And I've reached out to her. She's trying to make some sort of global resolution, but it's also my understanding that there's a hold on him out of Okaloosa County. So we've got a plea. I think we're close to having the case resolved, but if we could maybe have another pretrial, maybe we could get everything together for global.
All right, maybe June 19th?
Yeah, I think that's close to the time when his other arraignment is in the other case.
His other arraignment's probably going to be the 16th.
Yes, that sounds right.
You want to put everything on the 16th or put it on the 19th?
16th would be great.
We'll just put this case on the 16th for this arraignment.
Thank you, Judge. That's all I have.
Have a good day.
You're welcome.
Mr. Turner?
Wesley Ledbetter?
Turner?
Morning, Judge. Joe Turner here with Wesley Ledbetter in case number 24-1802 and 25-744. This time he wishes to withdraw his previous interplea of not guilty and interplea of no contest to the following. In 24-1802, one count of DWLSR habitual. It's a third-degree felony punishable by max 5 years DOC, $5,000 fine, or both. In case number 25-744, one count of DWLSR habitual, third-degree felony punishable by max 5 years, $5,000, or both. And also in 25-744, one count of misdemeanor resisting an officer without violence, punishable by up to a year in the county jail. The agreement is as follows. He will be sentenced to 1 year and 1 day in the Department of Corrections, court costs and fines as laid out on, I believe, Forms C and E. He's got 63 days credit, which is the shortest credit, so that'll be the effective credit for the cases. DHSMV may apply additional penalties, DNA sample if required, forfeit items seized.
That's the agreement with the state?
It is, Your Honor.
Promise by the testimony you're about to give us the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am. All right, Mr. Ledbetter, you can lower your hand, sir, and state your name.
Wesley Moore Ledbetter.
Ledbetter, you just heard the announcement of Mr. Turner. Is that correct?
Yes, sir.
Is that your understanding of the agreement with the state?
Yes, sir.
Has anybody promised you anything different?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning which would impair your ability to enter the agreement or understand any of the terms and conditions of it?
No, sir.
I've been handed a plea waiver consent form. There's the front. On the back, it's a signature of the defendant line. Is that your signature?
Yes, sir.
Have you had the opportunity to read that agreement?
Yes, sir.
Have you had the opportunity to go over your cases with Mr. Turner?
Yes, sir.
Have you had sufficient time to speak with Mr. Turner about your cases?
Yes, sir.
Are you satisfied with your lawyer's advice and counsel?
Yes, sir.
Do you understand that by entering the plea, you're waiving your right to go to trial?
Yes, sir.
You're waiving your right to require the state prove the allegations against you.
Yes, sir.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence.
Yes, sir.
You're waiving your right to present any defenses that you might have to the allegations.
Yes, sir.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf. You're waiving your right to testify to remain silent at the trial, which would be a decision you'd have to make.
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence. Are you doing this for your own free will? Mr. Ledbetter, do you feel this plea is in your best interest?
Yes, sir.
You understand if you're not a citizen of the United States, you may be subjecting yourself to deportation proceedings by entering the plea? Mr. Farrer, prima facie case, please.
Your Honor, the state is prepared to prove in case number 24-1802 that the defendant Wesley Moore Ledbetter on May 26, 2024 did operate a motor vehicle upon the highway of the state of Florida by being designated a habitual offender with his license suspended. And the state is also prepared to prove in case number 25-744 that the defendant Wesley Moore Ledbetter on March 18, 2025 did knowingly drive or operate a motor vehicle on the highway of the state of Florida while being designated a habitual traffic offender and his license was suspended.
I'll find it's a prima facie case. I'm gonna find that Mr. Ledbetter's pleas were freely and voluntarily made after consultation with his attorney. Is there any reason we can't go forward?
No, Your Honor.
Going to accept his plea. In case number 24-1802, he's adjudicated guilty of driving while license suspended or revoked habitual. Case number 25-744, he's adjudicated guilty of driving while license suspended or revoked and also resisting an officer without violence. On each of the felonies, he is sentenced to 1 year and 1 day in the Florida Department of Corrections. They're to run concurrent with each other. He's given credit on both cases for 63 days time served. He's assessed fines and costs in the lowest case number of $1,253. Those include discretionary costs of $2 of local law enforcement education, a $65 assessment of additional court costs, and a $700 discretionary fine. And also in the higher case number, he's assessed $518 in fines and costs, and those include discretionary costs of $2 of local law enforcement education and a $65 assessment of additional court costs. The fines and costs are reduced to a civil judgment. There's no restitution applicable in the case. Department of Highway Safety and Motor Vehicles may apply additional penalties. If he's required to give a DNA sample, he must submit one. He'll forfeit any seized items. On the resisting officer without violence, he is sentenced to 63 days in the Bay County Jail, given credit for 63 days time served. All the sentences will run concurrent with each other. Have I left off anything?
No, Your Honor. We'd ask for a recommendation to Washington CI, please.
I will recommend that the Florida Department of Corrections housing Mr. Ledbetter at the Washington Correctional Institute. Mr. Ledbetter, you have 30 days to file your notice of appeal. If you wish to appeal this judgment and sentence, if you'd like to have an attorney to represent you, and you can't afford one, one may be appointed to represent you at no charge. Good luck to you, sir, and you step over and be fingerprinted.
Thank you, Judge. That's all I have.
Have a good day, Mr. Turner. Ms. Bennett?
Morning, Judge. I have two on your docket today. We have Mr. Jeremy Forward. He is here in case number 243934 and also in 3 violation of probation cases. And could we come on up, Jeremy, and waitress right here, okay? And if we could approach for a moment.
I've just had a sidebar with Ms. Bennett and Mr. Pereira, and based on those conversations, I believe Ms. Bennett has made an ordinance motion to release Mr. Ford on his own recognizance on the.
Is that a motion docket? Is that the motion docket tomorrow?
Yeah, we can take him off to tomorrow's docket.
It was on the motion docket for tomorrow, but we'll just.
In that case number, what's the newest case number? 24 CF 3934. And the state has no objection to releasing Mr. Ford on recognizance on that case. He'll be reinstated. He's going to be. My special conditions. I'm going to release him back on. I'm also going to ROR him on the violation of probation. He's back. He'll have to report to probation. You need to speak to him. We need to give you another court date. When do y'all want to place that on the docket?
And Ms. Blanket, Mr. Forward asked how much time he would need to finish his probation, how much time he has left, if it's enough time to finish all his conditions, because he wants to finish them.
July 17th. Is there any way I can get like an extension on my special conditions?
We can bring him back in June and we will.
Yeah, let's do that. We're going to release you. You're going to need to check in with you. You can go over there and speak to the probation officer. You'll be back on probation. I'm going to release you on your own recognizance on all the violation of probation and the new charge. I'm going to set you to come back June.
Yeah, let's set him
June 10th. Is that correct?
Yes, sir.
June 10th at 9 o'clock. Okay.
And go with them and then just follow your.
Ms. Ford, just go back over there and whatever and follow those instructions. Okay. And we'll take him off the docket for tomorrow.
Thank you, sir. Next, I have Christopher Coatney. Mr. Coatney is here in 2 cases, 21-560 and 21-3117. We have received the audio of a second proffer that the co-defendant has made, and you already signed an order to have that transcribed. That audio is with Ms. Sexton. She believes she'll have it done by the end of next week. And we're in the process of scheduling the co-defendant for depositions. We had a tentative date, but we're unable to confirm it with the co-defendant's attorney, so we'll have to go back to the drawing board on that.
That's for Mr. Stone, is that correct? Excuse me, any reason to set it before July 24th? We'll set it for July 24th to allow Ms. Bennett to schedule that that deposition of the co-defendant, okay?
That's all I have this morning.
Have a good day.
You too.
Ms. Jewell?
Mr. Hicks. There's Jermaine Hicks coming forward in case 22 CF 38. He's going to be entering a plea of no contest to one count of sale of methamphetamine, unlawful two-way communication, and possession of paraphernalia. Paraphernalia is an adjudication and time served. I believe the count one is going to be consolidated, so that we'll only have the remaining counts on that we're pleading to. As to the felonies, he'll be adjudicated guilty, sentenced to 48 months in the Department of Corrections. Those will be concurrent with one another. Court costs and fines in the amount of $1,078. He has 351 days of jail credit, DNA sample, forfeit any seized items, and actually testify truthfully against any co-defendant. However, that co-defendant already pled and is in violation status. Always swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
Mr. Hicks, you can lower your hand, sir, and state your name.
Jermaine Hicks.
Mr. Hicks, you just heard the announcement of Ms. Jewell, is that correct?
Yes, sir.
Is that your understanding of the agreement with the state?
Yes, sir.
Has anybody promised you anything different?
No, sir.
Are you under the influence of any drugs or alcohol this morning which would impair your ability to either enter the agreement or understand any of the terms and conditions of it?
No, sir.
I've been handed a plea waiver and consent form. There's the front of that document. On the back says signature of the defendant line. Is that your signature?
Yes, sir.
Have you had an opportunity to read that agreement?
Yes, sir.
Have you had an opportunity to go over your case with Ms. Jewell?
Yes, sir.
Have you had sufficient time to speak with Ms. Jewell about your case?
Yes, sir.
Are you satisfied with your lawyer's advice and counsel?
Yes, sir.
Do you understand that by entering this plea, you're waiving your right to go to trial?
Yes, sir.
You're waiving your right to require the state prove the allegations against you.
Yes, sir.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence.
Yes, sir.
You're waiving your right to present any defenses you may have to these allegations.
Yes, sir.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf.
Yes, sir.
You're waiving your right to testify to remain silent at the trial, which would be your decision to make.
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence.
Yes, sir.
Are you doing this for your own free will?
Yes, sir.
Mr. Hicks, do you feel this plea is in your best interest?
Yes, sir.
Do you understand if you're not a citizen of the United States, you may be subjecting yourself to deportation proceedings by entering the plea?
Yes, sir.
Mr. Ferrer and Ms. Jewell state or defense where any DNA evidence that exists which might tend to exonerate Mr. Hicks.
No, Your Honor.
Prima facie case, please.
Your Honor, the state is pre-approved in case number 22-3816 CF. The defendant Jermaine Hicks on September 9, 2022 did unlawfully and knowingly sell or possess with the intent to sell a substance or tested positive for methamphetamine. That's the count 3. The state is prepared to prove that Jermaine Hicks on September 9, 2022 did unlawfully use a two-way communication device in furtherance of the commission of sale of methamphetamine.
I'll find there's a prima facie case. I'm gonna find that Mr. Hicks' plea was freely and voluntarily made after consultation with his attorney. Is there any reason we can't go forward?
No, Your Honor.
I'm going to accept his plea. Okay, in case number 22 CF 3816, he's adjudicated guilty of sale of methamphetamine, unlawful use of a two-way communication device, and possession of paraphernalia. On the 2 felonies, he is sentenced to 48 months in the Florida Department of Corrections on each to run concurrent with each other. He's given credit for 351 days time served. He's assessed fines and costs of $1,078. Those include discretionary costs of $2 of local law enforcement education, a $65 assessment of a district court cost, a $150 discretionary public defender fee payment, a $50 discretionary drug abuse fund payment, and a $200 discretionary fine. The fines and costs are reduced to a civil judgment. There is no restitution applicable in the case. If he's required to give a DNA sample, he must submit one. There is a requirement he testify truthfully against his co-defendant, but the co-defendant is pled. On the possession of paraphernalia, he's adjudicated guilty since the time he served in the Bay County Jail, given credit for that time. That sentence would also run concurrent with the sentences received in the felonies. The state has consolidated count 1. Have I left off anything?
No, Your Honor.
Mr. Hicks, you have 30 days to file your notice of appeal. If you wish to appeal the judgment sentence, if you'd like to have an attorney to represent you, and you can't afford one may be appointed to represent you at no charge. Good luck to you, sir.
Your Honor, I have John Bridget.
All right, let's head north to Wyandotte, and we will say good morning to Michigan's own Judge Mom.
Okay, and that's fine. Okay, sir, please raise your right hand. Do you solemnly swear or affirm the testimony about to give in this matter to be the truth, the whole truth, and nothing but the truth?
I swear.
Okay. And you heard the plea that was placed on the record, correct?
Correct.
As to the charge of domestic violence, how do you plead?
Guilty.
You've gone over your advice and rights with your attorney, correct?
Correct.
And you understand all of those rights?
Correct.
You also understand by entering into a plea that you'll be waiving some of those rights?
Correct.
And you understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency?
Yes.
And you understand what the 769.4A status is, correct?
Yes.
Knowing all of that, do you want to continue with your plea?
Yes.
And has anybody promised you anything, threatened you, or forward to any way for you to enter into a plea?
No.
Counsel, any immigration issues?
There are no immigration issues, Your Honor.
Okay.
I'm prepared to work here if you'd like, Your Honor.
You may proceed, counsel.
Now, Mr. Marzak, you were living in the city of Riverview on the 24th day of July of 2024.
Yes.
And you were living with a woman in a domestic relationship. She is the victim in this case, Marina Carroll. Is that correct?
Correct.
And at that time, the relationship got to the fringe where you were breaking up with her?
Yes.
And in the dispute, in the argument with her, you put your hands on her without her permission, to wit, assaulting her contrary to the law of the state of Michigan. Is that correct?
Correct.
And you realized that you had no right to do that. You admit you were living in a domestic relationship that had happened in Riverview in the county of Wayne, state of Michigan.
Yes.
And we may address it later, but you haven't seen or contacted her since this incident, since you participated with the police in 2024. Is that correct?
Correct.
Judge, there's way more than enough, I believe.
All right. The court does find the plea as knowing, voluntary, and factually accurate. The court will accept your plea as charged, determine your eligibility under 769.48 at sentencing. You will receive a sentencing date from probation, and the court will note that I believe this matter, I recall correctly, the prosecutor's office presented. Yeah, so the warrant wasn't authorized on April 16th of 2025, so there wasn't any delay by either the Riverview Police Department, Mr. Zelnick, or Mr. Rivers, or the court. So I just wanted that to be placed on the record. Sir, if you were to test today, what's in your system?
Marijuana.
Do you have a prescription for that, sir?
No, only recreation.
Okay, so when's the last time you used it?
About a week ago.
Okay.
You told-
You've been in court?
Have you used it since you've been in court last week?
No.
We were here last week.
Court was 1 week ago. So-
Yes.
Okay.
I think you made it clear then, and Judge, if you want to revisit the bond conditions, I'm sure he knows, I've gone over it 10 times, so is the victim advocate with him, but if you'd like to say it one more time.
All right,
So,
and you have a copy of the bond conditions as well, correct, sir? You're not to possess or consume any alcohol or drugs that are not prescribed. You're not to have any contact with Ms. Carroll. That's phone contact, text message, email, social media, third party, anything of the like. You're not to appear at her address or place of employment. You're not to possess any firearms or weapons, okay?
Yes.
All right, please stop over probation. Somebody will be with you shortly, just to confirm the sentencing date.
not to belabor it, do you have any immediate plans to leave the jurisdiction of the state of Michigan? Because you'll need permission from the court if you have any trips, you have any business trips, anything else. If you have any now, please let the judge know, because sentence will be in a couple of weeks, but if you have plans of going, do you have any plans?
No
All right, very good. Thank you, Judge.
Okay, all right, thank you. All right, please stop over probation. You'll receive your pre-sentence interview date, your pre-sentence interview paperwork, as well as your sentencing date.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, thank you. All right, so counsel, I know that we have both Mr. Goldpaw and Mr. McNally here for Mr. McFarland, but I'm also going to just have Mr. Fenwick in the courtroom. I'm going to handle his matter, and then we're going to call Mr. McFarland.
So we're going to stick with Judge DeSanto, but I wanted to show you real quick. This is Clayton County, Georgia, and this is just a still that I took from their current proceedings, and look at how everybody's just lined up down the hallway. This is first appearance court, and it amazes me because every day in Clayton County, this is what you see, just a line of people down the hallway. There are so many of them. I don't know a lot about Clayton County, but it seems like they have an incredibly busy judicial system there. It's nuts. Anyways, back to Judge DeSanto.
And we've elected, based upon our conversation, to waive that 20-yard exam.
Okay, and so, Mr. Fenwick, you heard everything that your attorney just gave on the record, correct?
Correct.
And you understand that you do have the right to have a preliminary examination where it must be shown that the crime was committed and probable cause exists to charge you with that crime. Do you understand that?
Yes.
And you also understand that by waiving your right to your preliminary examination, you will be bound over to the court for further proceedings on the charges in the complaint and warrant. Do you understand that?
Yes.
And have you received notice of those charges?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to waive your right to your preliminary examination?
No.
All right, the court does find then that examination hasn't been waived, the defendant is bound over to the court for further proceedings. You are to appear in circuit court on May 29th at 9 o'clock in the morning at the Third Circuit Court. Bonding and conditions are continued. Anything else, counsel?
Not for defending, Your Honor.
Okay. All right, thank you. Good luck to you, sir. Okay, Mr. Gopal, without us losing you, can you go get Mr. McNally?
Yes, sir.
Okay, in the meantime, we will handle, this off, Mr. Gopal.
Did anyone zoom in for Mr. Rice?
For Mr. Rice?
Yeah, she had to call down because they didn't assign,
Oh, okay,
and somebody unbeknownst to us is gonna do it.
okay.
All right.
Okay, so Mr. Maverick, do we need to, do the three of us in the chat in chambers, or we could go on Mr. McFarland?
Preferably, yes.
In chambers, okay, all right. I'm gonna have the two of you jump in chambers real quick. I'm just gonna do this adjournment for Mr. Dubin. We are on the record of the matter of the state of Michigan versus Wendy Correa, 25657. And, hearings counsel?
Good morning to you and your staff, Your Honor. Attorney Maxwell Dubin, P number 86012 on behalf of Miss Correa.
All right, thank you. And, Wendy Correa, can you please state your name for the record, please? You're muted.
Wendy Hope Correa.
Correa, okay, thank you. And counsel, you had the opportunity to speak to the prosecuting attorney today during the probable cause conference, correct?
I have,
Yes.
Your Honor, we are requesting a adjournment of the PCC. I did just receive video yesterday. I'm just asking for an adjournment of the PCC. Additionally, I have went over my client, her rights to the 21-day rule. She is willing to waive that here today as well.
Okay, and so then does the 12th of June work?
The 12th of June will make it work, Your Honor. I appreciate it. And there is one more thing I want to address. I know you're busy, so I can't.
Just one moment, what time is it now? 9:15 a.m. Okay, and what was that, counsel?
I was just want to do a quick address bond very briefly, Your Honor.
All right, well, bond is, you mean bond conditions?
Correct, Your Honor. Just the tether, Your Honor. My client does work in the healthcare field. She's on her feet all day. It's causing some swelling on her ankle. What I was just going to request is that she do a daily sober link if the court would consider that. She's been excellent with the tether on her ankle. She's had no problems with it. It is just causing her some health issues with her ankle. So I was just requesting, of course, I know it's up to the court's discretion, that she just be able to do a daily sober link instead.
Okay, and counsel, I can appreciate that, but however, the allegations are she was at a .030, and the court has some serious concerns for the safety of the community as well as the benefit of your client. And The court is not going to amend the tether at this point.
Okay, Your Honor, I appreciate you hearing me out. Thank you. Great to see you as always. And I hope you and your staff have a wonderful rest of your day.
Thank you, you as well. Have a good weekend.
Bye. You too.
Thank you. Okay, let me just go back in chambers with counsel, Mr. McFarland.
Okay, well, she goes back to chambers. Let's go back to Judge Simpson, where Miss Jones' entire world now seems to have been turned upside down.
Thank you.
Your Honor, we are going to be requesting an adjournment to review discovery.
Probable cause conference will be adjourned 5th, 2025, 9 a.m. Bond.
Thank you.
Calls the case of the people versus James Harbin.
People.
One Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Harbin. Mr. Harbin. He's at St. Joseph Hospital. Correct. I changed this was the one I changed his bond on. I don't know that we have a indication, but what I will do is I'll adjourn it to the 12th. Let's see where everything is at. Thank you. All right. June 12th, 2025, 9 a.m. Bond. Court does call the case of the people versus Germond Matthews.
First Assistant Public Defender Queen Anderson, on behalf of Mr. Matthews, who's approaching. State your name for the record, Mr. Matthews.
Matthews. Thank you. You're requesting an adjournment.
Yes, Your Honor, we referred this to the investigator. I did hear Your Honor give the co-defendant June 12th.
Will that work?
That should be
So
fine.
the co-defendant was,
Yes, Your Honor.
all right. Probable cause conference, June 12th, 2025, 9 a.m. Bond continue.
We'll come talk to you before the stuff, okay, but call me or Monday, once you know what happens.
Court does call the case of the people versus Jennifer Jones.
Hello, Your Honor, I'm sorry. Can you hear me?
Yeah, we can hear you.
Okay, cool.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Jones, who is present via Zoom. Ma'am, can you please state your name for the court?
Jennifer Lee Jones.
Thank you, Your Honor. At this time,
She's upside down, but that's okay.
she is, but she's here.
I don't want to lose you.
Your Honor, at this time, we would request to set this case for preliminary examination. I believe discovery is complete.
You believe, okay.
I'm sorry, Your Honor, I didn't know how to fix it.
You did not what?
I didn't know how to fix it to make me go straight.
No, you're okay. You're okay.
I'm sorry.
No, you're fine. You're fine. We'll be able to deal with it. Miss Pate is just happy you're here.
All right,
Okay.
This is my first time on Zoom.
Yeah, I wouldn't know it. You're such a pro at it. You're doing well.
I'm upside down.
Yeah, I know. It's okay. It's okay. Will the people have their witnesses available on the 3rd or what? What's the date? The 5th? Yes, the 3rd.
We'll do our best, Your Honor.
Preliminary examination in person, so you don't have to do this again. June 3rd.
Okay, I gotta go there because I live in Flint. June 3rd.
2025.
Uh-huh.
That's 9 a.m. That will be before Judge Perry.
All right, cool.
All right, yes. Your bond will continue, okay? Miss
All
Jones,
right.
you have a great day.
You have a blessed day too. Holla at you.
Bye-bye.
Thank you, Ms. Jones. Thank you, Your Honor.
All right.
Well, that was really interesting because, to be honest with you, when we saw her earlier, Bailey, you thought she was probably going to explode, and I wasn't sure what we were going to get. She turned out to be jovial. I wasn't. Not sure what we're gonna get. And the upside down was just the icing on the cake. Bailey, good for you developing healthier habits. Keep it up. Allow yourself a little something. For me, about once a week, I allow myself a Coca-Cola, which I stretched over 2 days and just finished off during the stream. But I can tell you that a few years ago, I started working harder and harder at paying attention to what I put in my body and trying to eat, especially as clean as possible. And there's certain supplements that I take and whatnot. And I will tell you that I feel better in my 50s now than I did in my 20s. So good on you. Keep it up. Let's go back to Florida and Judge Brantley Clark.
Ready for trial, and I will get ready as soon as possible.
All right, we'll set it for July 24th at 9 o'clock.
Bien, ¿para cuándo queremos programar esto? Su señoría, si nos pudiera dar la fecha de la vista previa al juicio para julio. El señor White piensa que está listo para juicio, así que yo me prepararé. Bien, les voy a dar la fecha de 24 de julio a las 9 en punto.
I will see my new client at the jail as soon as I can fit him in my schedule.
Veré a mi nuevo cliente en la cárcel en cuanto lo pueda programar en mi horario.
All right. You call your next case.
Your
Is
Honor,
that
may
all
the
from Mr.
interpreter be
Ricardo
excused?
today? Is that all from Mr. Ricardo? Yes, sir. Thank you for your assistance.
Thank you, Your Honor.
Your Honor, the next case is Anthony Worley, 24CF3355.
Worley?
Your Honor, on this case, we also have deposition scheduled for August 14, but we have a motion to withdraw scheduled for tomorrow that you might choose to hear today if you decide.
All right, Mr. Worley, are you objecting to the motion to withdraw?
Well, he said, I ain't got a way to pay him. I told him I got money in my safe at my mom, but he refuses to, he don't want to keep going, so. And honestly, he's did nothing for me. I mean, you know, he showed me nothing, so.
You don't object?
No, I mean, I got the money to pay him, but I told him, I said, it's in my safe, and my mom ain't got it, because she can't work that safe, you know, she don't want to get into it. And I've been here on this text message for going on 4 months now. And, you know.
I'm gonna go ahead and grant the motion to withdraw. I don't think it's that old of a case. Do you want to be considered for the officer? But you have money in a safe?
Yes.
All right. There's nobody that you can.
My mom, she's 84 years old. She just turned 84 and, you know, she can't work it.
Pardon?
My mom, she's 84 years old. She don't know how to work it, no. She don't know how to work a safe. My truck's about to be repoed, and my van, and I need to get out making payments.
Well, I mean, you're not getting out today. There was a motion to revoke bond and it was granted. You're being held without bond. Is that correct?
You give me a bond when I first come in.
Yes, sir. But the state filed a motion based on some allegations of violation of a release. You don't have anybody that can help you get your money?
Unless my mom would, I mean.
What I'll do is I'm gonna set this for June 19th at 9 o'clock and see if you can contact your mother and see if she can get your money to hire another attorney, and I'll grant Mr. Henson's motion to withdraw. And then we'll take that up on June 19th if you've got another attorney or not. Okay?
All right. But can I get time served on that?
No, sir. I'm not taking any not right now. Okay?
All right. Thank you.
I conclude today's.
Thank you, Your Honor. That concludes my business.
Yes, sir. Is Mr. Selene's client out? All right,
A personal request to all of you who are viewing right now. First, thank you for joining us today. But if you're not a channel subscriber, would you please consider doing so? We are 20 subscribers away from cracking the 18,000 mark for the channel, and I would love your support. If you would be so kind, be very much appreciated. Let's go back to Judge Simpson.
They've got more. Who? Detlefs. I already called that, right? Yes. Correct. Court does call the case of People versus Benjamin Detlefs. This is a recall.
Assistant Public Defender Jay Bellinger on behalf of Mr. Detlefs.
May date 890 out.
Mr. Detlefs, can you please restate your name for the record?
Yes, Benjamin David Detlefs, Your Honor. Detlefs.
And Your Honor, it's my understanding that the court is now in receipt of the competency evaluation and also the finding in order. I did indicate to the court via email that I did only include the case number that was indicated in the report itself for the finding in order. Would ask that that be signed and would also ask to address bond.
All right. I've signed the order. The defendant, after the court has reviewed the report, still remains incompetent to stand trial, but likely to obtain competency with treatment. And so the court will set the next review hearing for, August 14th, 2025, 9 a.m. as to bond.
Thank you, Your Honor. As to bond, Your Honor, my client has been in the Washington County Jail for the last 259 days. His current bond is set at $1,000 cash or surety and $1,000 10% on his respective cases. I have talked to my client. He advises that he can attend smart recovery meetings at the Annex building. He has a local Ann Arbor address. He advises that he can get his medications there, that he can get his therapy there, that he can do drug testing there as well. He advises that he can attend that 3 times a week. My client also advises a more recent update with regard to his medical. He has a chipped tooth, Your Honor, that's causing him a lot of pain. He's asking for release so that he can get that taken care of with his own dentist, considering that he may be at a bit more of a detriment in terms of getting medical treatment for that within the Washington County Jail. I am asking that the court release him on tether. Home confinement would be okay in terms of flight risk, Your Honor. I don't know that the issue is necessarily flight over potential dangers of the community. I do believe that that would be alleviated with a home confinement tether GPS for tracking purposes so that he can go and start taking care of his mental health and his medical issues.
Response.
Your Honor, I would ask that bond remain as currently set. The defendant's charges are all basically for assaulting police officers and correction staff. The defendant is currently incompetent but restorable. If there was a very clear documented plan in place for the defendant to address his mental health issue if he was out of the jail, that would be something I would be more amenable to. But I think the best place, unfortunately, for the defendant in order to regain competency and make it so he's less likely to reoffend is to stick with the current plan, have him receive the treatment from the CFP and hopefully regain competency in a short time.
Your Honor, to that, my response would be that I will be in contact with Sarah Stewart from CMH so that I can see about working on a treatment plan for him, and then I will file a motion with the court so that we can readdress this at a different time.
All right. And I'm not going to do anything unless I can see a plan for this.
Okay.
So the motion for bond modification and reduction is denied at this time.
Thank you.
All right.
I'll be in contact with Sarah and we'll see about getting a plan started, okay? All right. Thank you, Your Honor.
Thank you. Court recalls the case. Hang on. Gotta make sure I see the name. Tequila Evans Gate.
Karen Dadush on behalf of Ms. Tequila Evans Gayan.
State your name, please.
Tequila Evans Gayan.
That's it. Go ahead.
Your Honor, the prosecution has offered that Ms. Tequila can plead to an added count 2 attempt resisting police officer, with no objection to HIDA, with count 1 dismissed. Here's all the forms.
All right.
R.
And that's a guilty plea?
Yes, sir.
All right, the plea form the court has in front of it is indicating that she would be pleading to attempted resisting and obstructing a police officer, the 1-year misdemeanor. Upon her successful guilty plea to that charge, count 1 would be dismissed, and there's no objection to HIDA. That's the court's full understanding of the.
Yes, Your Honor. Yes, Your Honor. And for the record, we are going to be requesting that she gets this under HIDA.
Pardon?
We're requesting that this be under HIDA. I don't know if I had to say that on the record.
Didn't you already say that?
Well, she has no objection to HIDA. That doesn't mean I'm requesting it.
Anything else you got?
Anything else?
All right, I'm going to talk to Tequila now. Can I have her sworn?
Raise your right hand. Do you solemnly swear in the firm the testimony you're about to give you the truth, the whole truth, and nothing but the truth, so help you God? State your name.
Tequila Evans Gayan.
All right. And it is this court's understanding that you are going to be pleading guilty to an added count 2 of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that?
Yes.
All right. I further have to advise you that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes.
Understanding all of that, you still wish to plead guilty? And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights? Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Oh, that's the same thing. Mm-hmm. It's the same thing, actually. Yes.
You understand you're giving up your right to appeal of right. Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
January 20th, 2025, at the location of East Clark Road near Centennial Avenue in Ypsilanti Township, Washington County, state of Michigan, did you come into contact with Washington County Sheriff deputies?
Yes.
What happened?
They basically told me I swerved, my tail light was out, which it wasn't. But I guess they're allowed to do that because I guess there was a phone call in the area that basically there was some stuff going on in the area, so they just wanted to make sure it wasn't me. They seen me with a nicotine breeze. I didn't know that we could be detained for that. So I was kind of scared when I seen 6 police officers, and then they were trying to tell me to get out the car, but I didn't know I could be detained for a breeze. So I was resisting, and then they placed me in the car and basically told me, oh, okay.
So you resisted and obstructed them by not exiting your vehicle upon their request.
Yes.
Is that correct?
Yes.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
July 10th at 10 a.m. with Judge Washington.
July 10th, 2025, 10 a.m. before Judge Washington. Bond in this case will continue.
Thank you, Your Honor.
But take care.
Thank you.
All right,
Say her
be
name
real.
4 times.
Let's switch over to Judge Dad. He was off the bench for quite a little while, but he's back.
All right, so what are we doing on this one?
It says sentencing. But I've looked at the ROA. You already sentenced Ms. McGregor back in 2001.
Yeah, I know.
Probation order in the file.
I know, but I revoked her release, forfeited her bond.
Back in January. But according to Ms. McGregor, you sentenced her to drug court at that time.
I tried to help her. She didn't want to help. She didn't want to have any help. Let me just check something.
Sure.
Lisa, I believe I revoked her HIDA status.
Yeah, January 3rd, and then you wanted her screened again.
Yeah, and then I set a sentencing date for January 24th. I tried to talk to her.
Then she didn't appear.
Correct, January 14th. Failed to appear for chemical tests and subsequent failed to appear for probation appointment. January 13, revoked her release, forfeited the bond pending a hearing. So, yeah, when I revoked the HIDA status, it's time to be sentenced anew. So, first of all, she can explain to me and to us why she decided just not to show up.
Sure.
I'm gonna be completely honest.
No,
Yeah. In January, I was still on drugs.
you're kidding.
And I wasn't taking anything serious.
Oh, jeez, that's too bad.
And I recently, in March, I got off all of my prescription medications.
You what?
In March, I got off all of my prescription medications. One was a narcotic, and I've been trying to be and stay clean since March. And I just got a job recently when I got out of county, and I want to put this behind you.
No, I wanted to be president. I don't know what to tell you. I'm not real. You cannot, don't throw those crocodile tears
I'm
at
not
me.
trying to, I'm just scared. I'm
Well, you should be scared. You should be scared. You have been not a very good mother. Okay? I tried to help you.
I know you did. Thank you for.
You didn't want any help. If I gave you another chance, you still wouldn't want help. No.
Please give me one more chance.
No, 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 no. I begged you. I remember this woman. I begged you to turn your life around, to try to be a good mother. We would try to help you, get you into sobriety / drug court, and you wanted nothing to do with it. You wanted absolutely nothing to do with that. So please, save it for somebody else. If I sound harsh, I'm not apologizing. You ought to be ashamed of yourself. We have children we bring into this world. And the main reason the world's messed up like it is because a good percentage of people are just simply lousy parents or don't care or a combination thereof. We don't leave our children with our mother. That's not who they want raising them, and they're a lot more smart than we give them credit for. I don't care if they're 19, 9, or 9 weeks.
Yes, Your Honor.
Give me a first page of a register. I mean, I remember having this conversation with you. And your mother. And I gotta tell you, sometimes I know I'm spitting into the wind. I know it. I know it. I know I'm spitting. And sometimes it's like a 75-mile-per-hour wind coming back at me. But I don't want any regrets. I want to give everybody an opportunity, and I don't want taking anything that I did to my grave with me or dealing with my conscience as to why I didn't help. And I begged you. How many days credits do you have coming?
Judge, I believe there was already 3 days in the file.
Yeah, I know. Who was your probation officer again? I need Emily on this. Bring Emily in here on this.
Judge, the mother would like to address the court.
I don't know why.
She's the victim in this case.
I know she is. Come on up here. Yeah, but she's, come on up.
All right, thanks. Yeah, just move back. She's on the way.
How old are you?
27.
Your name?
Joyce Hammer.
What would you like to tell me?
Your Honor, I've been through a lot with this child. And I've tried everything, and I even pleaded with you to help me get her help, to get her straightened
We
around.
tried. I only have so many resources here.
I definitely understand that. I want you to do what you feel is best for her to get her straightened around. I am raising her 2 kids.
I know. You were then, you have been, and you're going to for the foreseeable future.
And I'm doing, me and her father are doing the best we can. I don't know nothing about jail. I don't know if it's good, bad.
I don't think any of us want to visit there.
No, I don't.
I mean, I remember going in there when I was a lawyer, and I couldn't stand going in those little cubicles with those guys. Their breasts stunk, they stunk.
And I will not take my grandchildren there to see her if that's the case.
Your name?
Emily Casino.
You got anything to say on her?
I haven't seen her since she showed up for her bond conditions and she didn't do one thing.
I don't know. Lisa, do you have, how many days credit does she have coming? Can you tell me? Well, I don't want to listen to anything you have to say, Mr. Gay.
I'm sorry, as far as credit, I know she told me that she was incarcerated she just got out, I believe, on Tuesday. She was incarcerated for 5 days.
Yeah, in my case, I arraigned her on May 16th. When did you get out?
Thursday, Your Honor.
Today's the
22nd.
So she got out the 20th. So she's got 5 days credit coming from that. And she's got 8 days credit total coming, I think. I don't see anything else. They're gonna cancel the bond conditions out, Lisa. I begged you. I remember this one. I'm not gonna feel sorry for you. What has she got, 8?
That's all. I do remember she was in custody when she got referred for sobriety court, but I don't see anything in the file to tell me how long she was, if I'm honest. So I don't want to guess.
How much does she owe, Lisa? Can you tell me?
600.
She can have that paid today, Judge.
Sometimes people force us to do things we don't want to do. You need to straighten out your life. 200 fines, 300 costs, 75 victims' rights fee, $50 justice assessment, 6 1/4 in 60 days. You'll pay 30 more, or you'll serve 30 more if you don't pay your fines. Credit 8. So she's going to serve 52 days. If she pays her 6 1/4 today, you have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. I wish you would have listened to me. Good luck. Have a seat.
No, you're gonna have to see what you're gonna do.
What a shame. I don't know if you guys caught it, but at one point during this, she was on HIDA, which means if she would have followed through with her requirements, this whole thing would have been dismissed. And at some point, he removed her HIDA, and now it's a mess. I agree with him, though, when he says he's talking about part of the problem in the world being the people that are raising the children. I don't disagree at all, personally. But if you disagree, let me know in the comments. Let's get back. Oh, by the way, the crowd has spoken. At the top of the hour, we will go into overtime, and I will give you a bonus half hour today.
Charge will be dismissed. That's punishable by up to $250 in fines, 45 days jail, costs or all those. Do you understand that, sir?
Yes, Your Honor.
Did you sign, read, and understand an advice of rights form today?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights. and there will not be a hearing or a trial. I don't see where you signed one, did you? Yes, I do. Okay. You understand that?
Yes, Your Honor.
All right. So, do you have any questions on your rights?
No, Your Honor.
For the charge of attempted possession of drug paraphernalia, how do you plead?
Guilty, Your Honor.
Were you on April 27 to 25 at 10:04 p.m. on Jefferson, near Vreeland and Trenton in a motor vehicle?
Yes, Your Honor.
And did you have a crack pipe in the vehicle?
Yes, Your Honor.
Was it yours?
Yes, Your Honor.
Did you know it was there?
No, Your Honor.
Where was it? You didn't know it was there? Yours? Come on. Did you know it was yours or not? If you didn't, you didn't.
I didn't know it was there. I knew
You were using it all over the place, and you put it in the truck once and you didn't remember you put it there. Is that fair?
Yes, Your Honor.
And also you had bud cans and everything else, beer all over the interior of the vehicle?
A few empties, Your Honor. Nothing more than that.
All right. They just made it sound like Love was found in possession of used crack pipe and open Bud Light cans in the vehicle. Beer was spilled throughout the truck. I don't know what that means. I mean, sounds like somebody had a free-for-all. But at any rate, are you on probation or parole?
Yes, Your Honor.
For what?
Here.
To me?
That through the Hessen.
Judge Hessen?
Just closed out case the 13th.
Well, but were you on probation on?
No,
hang
Your
on,
Honor.
on April 27th? Were you?
No, Your Honor.
Anybody forced you to plead guilty?
No, Your Honor.
Please accept it to that charge. I'm gonna have to address bond on him. What kind of record has he got?
Your Honor, he's currently on probation for a narcotics use, was put down from felony, I believe before that, it's some from 2017, a marijuana charge that was dismissed.
Didn't you just plead in the Wayne County Circuit Court to something, some kind of on May 13th, right?
No, that was here at 33rd, Your Honor.
And that was in front of Judge Hudson?
Yes, Your Honor. I think,
well, you got all
the
kinds
other
of.
judge was still in it.
All right. Are you doing anything, is he doing anything as a condition of bond on her case? Can you tell me?
What are you doing as far as bond? Are you doing NA, are you doing?
I have, right here. I got 80 hours of community service.
Are you testing?
Drug treatment, drug testing.
How often?
Drug treatment evaluation.
You going to AA 3 times a week?
I don't think I have a set amount on it.
All right, good enough. Here's what I'm doing. $500 personal bond. You cannot leave the state without the consent of the court. You cannot violate a law. I'm going to order a screening and assessment on this. You're to test weekly. You're to test weekly. No alcohol, no marijuana, no illegal drugs, AANA 3 times a week, or any combination of treatment and or AANA. Mr. Carmen, would you go over there and tell them that I'm saying on this case, if they just did a screening for her, I just need them to give me a copy of that and remind me that I didn't order one. In other words, if they just did it, I mean, it's silly to have them do one 10 days later. So if they just did one, they can just attach the screening and make a note per judge, attach Judge Hudson's screening. I'll give you a sentence date on this, but no alcohol, no illegal drugs, AANA or any combination thereof, at least 3 times a week, AANA or treatment or any combination thereof. So if she's ordering treatment, you're going to treatment, that will satisfy. If you go once a week, that will satisfy one of these, okay?
Yes, sir.
We're going to give you a new sentencing date here. But also on this other file, 25D645, 497A and B, that's out of Trenton as well. There's your appearances again.
Michael A. Carmen, 27324 on behalf of the town.
So this is going to be, in your name, sir?
Andrew Steven Syack.
So he's going to plead to defective equipment on this, and no ops will be dismissed, true?
Yes, sir.
To the charge, defective equipment, responsible or not responsible?
Responsible.
Please accepted, no ops dismissed, 120 on the defective equipment. Can you pay that today?
Yes, Your Honor.
You pay that today, and then you're going to go down the hall. you're going to go down the hall. And we'll go from there, okay? You're gonna get your screening or at least get your sentence date. We're gonna give you another A form. And you're gonna go down the hall and get your sentence date, which will be on what, please, Lisa?
June 9th at 1 o'clock.
June 9th at 1 o'clock. So I just need somebody to tell probation, John, that if they just did a screening for Judge Heston, and it sounds like they did, I don't need them to do one here. They'll just attach that report on her case and the police report on this case when they give it to me for sentencing. June 9th will be your court date. You can go down the hall and get your notice. Do you have any questions?
No, Your Honor, thank you, Your Honor.
Mr. Siak, how old are you?
39.
Kids?
Yeah, one girl.
You married?
No.
What are you doing this for? You're still on cocaine at 39? Come on, get over it. Let's be done with it, okay?
Yes, Your Honor.
You'll feel a lot better about yourself. I'm not sure you shouldn't get into sobriety court, drug court, to tell you the truth. How many of these drug cases have you had?
In the last decade, this is it. I'm just a recreational user. I've had problems with other substances.
Like what?
Opiates.
Yeah, that's worse than cocaine. What kind of opiates? Fentanyl, heroin, all the good Norcos, all the good.
Anything but fentanyl.
Are you still using those?
Oh, no, I've been clean since 2018.
Well, you're not clean if you're just driving around with cocaine.
They're clean at opiates.
We got to get you off the cocaine, too. I mean, come on. You want to get off of that, right?
Yes,
I mean, you need to think about drug court. Maybe I can help you. I think we can help you. You were just in front of Judge Heston on another one. I mean...
These all stem from the same, the original charge.
I don't know what you mean by that. They didn't start a separate action on the drug paraphernalia, did they?
No, but my truck got impounded, and then after getting it out of impound, I was pulled over shortly after that, and the paraphernalia was still in the truck from the previous charge.
Where do you work?
I'm an electrician. Currently, I just do side work.
You should try to make some money. Get a job.
Oh, yeah, I'm working on it.
Good. Give me those files, John. Good luck to you. I wish you well. Thank you. Have a good day.
Thank you.
Stay out of trouble. You go over there, and I want them to set you up with weekly testing, or at least it's going to have to be with Judge, in conjunction with Judge Heston's.
Okay, yeah, they have me tested just right down the street.
Go talk to them. Thank you.
Just to put that on the record, the county never sued him, man.
Brandon, Mitchell Cole, 23B1435268. Boy, since Deputy Pravanchi left, Lisa, huh?
It's a mess.
All right, looks like Dad's court is emptying out, so let's go back over to Mom, who has just returned from chambers.
All right, do we have the corporate file up here? No, this one's done. This one's done. Oh, we do have corporate, it's up here. Let me do this. Okay. All right, so let's go. Yeah, I have anything about him being on Zoom? Anything about Mr. Harris? No, I don't know. Okay, let's go on the record in the matter of the state of Michigan versus Tyrone McFarland. Oh, I thought I had this right there. Okay. Mr. Harris, is Mr. Harris? No, yes, Mr. Harris?
He's Mr. Rice.
Mr. Rice.
Lyle Harris.
Yes, Your Honor.
What about Wyatt Harris?
This is Wyatt Harris.
Yes, good morning, Council. You're not driving, are you?
No, I'm not, Your Honor. I'm
Okay.
parked.
Are you here on Mr. Corbett?
Yes, I'm standing in for Harold Collins.
Oh, okay.
I don't have to worry about
All right, so do you need a breakout room with Mr. Corbett, or are you good to go?
I'm good to go, Your Honor.
Okay, Mr. Corbett, good morning, why are you on Zoom? No, don't go there, Mr. No, I'm just gonna.
Currently stuck at laundromat. I have a flat tire. I've been waiting on my brother for 2 hours. He's takes his lunch break at 12. He's gonna come help me out with my tire then. Had a nail in it probably from leaving work yesterday. I'm sorry that I'm not there, Your Honor. I haven't never missed a court date. I'm always there, so.
You just have to log in on Zoom, you have to request permission, but the court will grant that permission based upon that, the court will take notice that you have not, missed court before. So, we're just, okay, Mr. Gopal, go to the restroom. Mr. Governor, Mr. Brown.
It's fine. It's okay.
Okay, so, I'm going to we'll do Mr. Corbett. All right, let's go. On the record of the matter of the state of Michigan versus Donald Corbett, 241310. And counsel, your appearance, please.
Good morning, Your Honor. Wyatt Harris, P54891. I'm standing in for the attorney of record, Harold Collins, with Mr. Corbett's permission. Is that correct, Mr. Corbett?
Yes, it is.
Okay, Mr. Corbett, your name for the record, please.
Donald Eric Corbett Jr. Good
All
morning,
right,
Your
so
Honor.
he's being scheduled for a jail review. The court held the last jail review March 27th of this year. And sir, you were beginning your management on March 31st, and you just started working for a painting company. And so have you started anger management, sir?
I haven't started the anger management. The last time I left your courtroom, I did go straight to the guidance center. I talked to, I think it's the lady that assigns the case managers. I go on June 3rd to see my case manager, and that'll be the same day I go right after to go see my therapist through there.
Sir,
Manager,
hold on, you told me March 27th that you were beginning anger management March 31st. I wrote it down. So now we've got 2 months. Why have you not started anger management?
that was through I forget what program it was, but when I went there, I called my probation officer instantly. It was a program they wanted me to do from Monday through Thursday from like 9 in the morning to like 5 in the afternoon. And there's no way I could fit that into my schedule with going to my substance abuse meetings and even just trying to work. I just started working a steady job 2 weeks ago.
All right, the first point to note here is that on November 14th of 24, this court sentenced Mr. Corbett to 180 days jail. The court gave Mr. Corbett credit for 50 days and suspended the balance. The court also ordered defendant to obtain a psychological evaluation, participate in random testing, not to use any alcohol or drugs unless prescribed, GPS tether, not to return to the home on 15th Street, not to have any contact with the complaining witness in this matter, and we set it for a jail review in December. The jail review was held in December. We adjourned it to February. February, we held it and then adjourned it again to March, and that's when you indicated all that, all those details, sir. So the court was determining whether or not it was going to continue to hold the jail reviews, but it is, because you have not yet participated in anger management. And have you participated in your psychological evaluation, sir?
Yes, ma'am. I go the 3rd to meet my case manager, and that's when I see the therapist.
All right, sir, let me be very, very, very clear. If you do not begin your anger management and have at least a few sessions in by the time we have your next jail review, sir, you will be serving the balance of your jail term. Do you understand that?
Yes, ma'am. I'll make sure I'll get it done.
And are you still working at the painting company?
No, ma'am. I work for a tree service now. It's called Little Monsters Tree Services. It's based out of Romulus. Actually one of the first bosses that's kind of understanding with the court and like things I have to do for probation. So he's not too hard on me with missing a day or two out the week.
All right, so we will set this for July 24th. Does that work for you, council, in the event Mr. Collins can't be here?
Yes, yes, that will work for either one of us.
July 24th at 9:30 a.m. in person.
I'll have that done for you, ma'am. Thank you.
Thank you. Have
a
good day.
Nice talking with you, Judge.
All right, good to see you, council.
For the record, just looked it up. Little Monsters Tree Service, 43 Google reviews, 5 stars. That is unheard of. So if you're in Southeast Michigan and you need tree service, check out Little Monsters, I guess.
Right, and so appearance for the people, please.
Good morning, Your Honor. This is Governor Manley for the people, number 87297.
Thank you.
Your Honor, John Goldpluck, P30758, on behalf of Mr. McFarland.
Mr. McFarland, can you please state your name for the record?
Huh?
Can you please state your name for the record?
Tyrone McFarland Stewart.
Tyrone McFarland Stewart?
Yeah.
Okay. And, all right, today's date scheduled for a review in this matter. The court and council are all in receipt of the Center for Forensic Psychiatry's determination after examination of Mr. McFarland upon request and order of this court for a competency evaluation, correct?
Yes, Your Honor.
All right, and as a result of that report, well, first, council, both of you have had an opportunity to review the report.
Yes, Your Honor.
Yes, Your Honor, on behalf of the defendant, I also had an opportunity to speak to Mr. McFarland and review that report with him as well.
All right, and council, are you stipulating to the report?
Yes, we are. On behalf of the defendant, we are.
And the people are as well, Your Honor.
Okay, based upon that, based upon the court's review of the Center for Forensic Psychiatry's report, the court is making the judicial determination that Mr. McFarland is incompetent to stand trial, would be unable to attain competency within the time afforded by statute, which is 30 days. The court's going to further state for the record that based upon this judicial determination that the defendant is incompetent to stand trial and not restorable, the court is concerned the defendant may be a person requiring treatment as defined by MCL 330.1401 or meeting criteria for judicial admission as defined by MCL 330.1515. The court's directing the prosecutor to file a petition for mental health treatment with the probate court. We're going to return next week on May 29th to see the status, because counsel in chambers, you raised the issue of your client's custody, that he's currently in Wayne County Jail, where he has been.
That's correct, Your Honor.
Where he's been awaiting evaluation by the Center for Forensic Psychiatry. The court will note that Mr. McFarland was originally scheduled for evaluation in December of 2024. And for reasons that are not known to the court, the defendant did not appear. I don't recall at this time because he didn't want to leave his cell or whatnot, or there was a misunderstanding or miscommunication within the jail and the Center for Forensic Psychiatry. In any event, Mr. McFarland was finally evaluated in April, and this report was provided to the parties who were present last week and adjourned to this week to confirm what the appropriate. Anything else for the people?
I agree with all. That he has been incarcerated more than 90 days. The report was received just recently, I understand that, April 14th. according to the documents here. And so, and that more than 90 days is before the second evaluation. Whatever reason he didn't appear, I don't understand. I wasn't doing it originally. And so I just want on the record that more than 90 days, and this is a 90-day mistake.
All right, that is noted for the record. The court also is noting for the record that the court has serious concerns for Mr. McFarland's safety as well as the safety of the public. And more so, Mr. McFarland has a significant criminal history in multiple states. One of which it looks like was in Chicago area in Cook County. I don't know if this is Mr. McFarland or not, because there's homicides and whatnot that are attributed to him.
I understand that, John.
And the court does have concerns that Mr. McFarland will not appear for the treatment that he's so desperate.
And I agree, and he agrees also that he does need treatment. So there is mine, no doubt, I believe his family's mine. That's the important part, and so therefore the appropriate procedure is to petition the.
Okay, so the court's going to order bonding conditions are continued. We're going to schedule the review for May 29th. At 10:45 a.m. And then, Mr. McNally, Laura will, Laura. After just, so that she can prepare the, finding of competency for me.
Thank you, Ron.
Okay, thank you. All right. Thank you, Mr. McFarland. Have a good day.
See you next week.
Okay, and Attorney Tucker, are you on, you're on Mr. Larsenese, correct?
Correct, Your Honor.
Have you spoken with the prosecutor or was your client?
Yes, we're gonna waive the exam.
Okay, I'm just waiting for our client to come in here and then we will, okay?
Yeah. Yeah, Ms. Chapman, so. I just want to know she's been here.
Yes, no, I see.
Oh, I know, I don't know.
Let's switch it up and go back to Bay County, Florida, where Brantley Clark is still working through his criminal docket this morning. It's been a very busy morning there.
Yourself, the deportation proceedings by entering the plea?
Yes, sir.
Mr. Ferry, Mr. Wilson, state or defense where of any DNA evidence that exists which might tend to exonerate Mr. Tubbs.
No, Your Honor. No, Your Honor.
Prima facie case, please.
Your Honor, the state has created proven case number 231865CF that on May 17, 2023, the defendant Caleb Terry Tubbs was in possession of a material that later tested positive for marijuana and it weighed more than 20 grams. The state has also prepared a proven case number 233694CF that on June 1st, on or about June 1st, 2023, the defendant Caleb Tubbs did unlawfully engage in sexual activity with AJ, a person between the ages of 12 or older than 12 but younger than 16. And a second count as well on that, on or about June 1st, 2023, the defendant Caleb Tubbs did engage with sexual activity with AJ, a person 12 years of age or older, less than 16 years of age. On that same day, the defendant was found to be in possession of marijuana with the intent to sell or deliver the controlled substance.
I'll find there's a prima facie case. I'm going to find that Mr. Tubbs' plea was freely and voluntarily made after consultation with his attorney. Is there any reasons we can't go forward?
No, Your Honor. No, Your Honor.
I'm going to accept his pleas. In case number 23 CF 1865, he's adjudicated guilty of possession of marijuana more than 20 grams and possession of drug paraphernalia. In case number 23 CF 3694, he's adjudicated guilty of count 1 felony battery, count 2 felony battery, and count 3 possession of marijuana with intent to distribute. On each of the felonies, he is sentenced to 5 years in the Florida Department of Corrections to run concurrent with each other. Each county is to receive 601 days time served. He's assessed fines and costs of $1,078. Those include discretionary cost of $2 of local law enforcement education, a $65 assessment of additional court cost, a $150 discretionary public defender fee payment, and a $200 discretionary fine. That's the cost on case number 23 CF 1865. On 23 CF 3694, he's assessed $518. Thank you. and that includes discretionary cost of $2 of local law enforcement education and a $65 additional court cost. The fines and costs are reduced to a civil judgment. There's no restitution applicable in either case. Is that correct?
That's correct.
That's correct, Your Honor.
If he's required to give a DNA sample, he must submit one. He'll forfeit any seized items. The Florida Department of Highway Safety and Motor Vehicles may apply additional penalties. He's to have no contact with the victim in the case. On the possession of paraphernalia, he sentenced the time he served in the Bay County Jail, given credit for that time. All the sentences will run concurrent. I'll recommend to the Florida Department of Corrections that Mr. Tubbs be housed in a correctional facility closest to Bay County. Have I left off anything?
No, Your Honor.
Mr. Tubbs, you have 30 days to file your notice of appeal if you wish to appeal this judgment and sentence. If you'd like to have an attorney to represent you, you can't afford one. One may be appointed to represent you at no charge. Good luck to you, sir, and you just step over and be fingerprinted. Step right over.
Mr. Bathis? You ready, Dan? Bathis.
We haven't been able to go to Judge Boyd for a couple of days because she has been in a jury trial, which are hard to cover on this channel. However, that case is now with the jury, and she is running through her docket, so let's go say hi to her.
All right, court is calling 2025 CR 00123, 1273W. I'll repeat that. 2025 CR 00123W, State versus Ali Jawana Kelly. Could I have parties announced?
Megan Galloway for the state.
Roberto Vargas, the defendant, ready to proceed, Your Honor.
And are you Miss Kelly? Are you the same Ali Kelly who was placed on deferred adjudication in 2025 CR 0012773W for the offense of possession of a controlled substance, penalty group 1, less than 1 gram, on February 5th, 2025 for a period of 2 years? Is that you?
Yes.
All right, state.
Violation of condition number 5 in Bexar County, Texas. The defendant, Ali Jawana Kelly, did then and there fail to report to the supervision officer as directed for the months of March, April 2025 in violation of condition number 5.
How do you plead to that? True or not true?
It's true.
Okay. All right, did you understand by pleading true to that, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 5?
Yes.
Court will find violation of condition number 5 true. Is there a proposed agreement?
There is, Your Honor. We are asking you to deny the state's motion to continue the defendant on her community supervision, but to alter and amend her conditions to include an updated top evaluation, mental health evaluation, the ISP program, and then weekly reporting until ISP.
All right, can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you're gonna have to keep your voice up. You can lower your hand, state your name for the record.
Kelly.
All right. So why did you not report?
I've been homeless and I'm not from the San Antonio area, and I'm requesting for assistance with bus fare.
All right, where are you from originally?
Beaumont, Texas.
I'm sorry?
Beaumont, Texas.
So what brought you here?
Moved here. I worked here. I lived here for a while, but I fell on hard times.
All right, and when you say you worked here, what were you doing here?
I worked at Jury Closet, Conduit Local.
Doing what?
Jury Closet housekeeping, Conduit Local as Verizon telemarketer.
All right, so did you come here for work? I mean, what's the reason why you came to San Antonio? Why not
I came here
somewhere else?
They work within this last year, so following hard times.
No, I mean, did you come here by yourself?
Yes.
All right, so you just came because there was a job here?
I just need
All right, do you have children?
1.
Age?
20.
And how old are you?
38.
And so is all of your family in Beaumont?
Yes.
All right, so how often have you been using before you were arrested?
I've been trying to get back into the workforce.
No, you're not listening to my question. You're on deferred adjudication for possession of drugs.
Yeah, and since then I've been doing everything that I possibly
So
can to get
before,
into the work.
I'm talking about before, How often had you been using?
Oh, before?
Mhm.
Recreational.
Okay, here's the thing. I was not with you. So I don't know how often you were using. So that's what I'm trying to, I was not with you.
I'm not really sure. I wouldn't say that it was an everyday thing.
And what were you using?
Smoking weed.
And what else?
I guess you would call it meth, amphetamine.
No, I mean, I wouldn't call it anything. I wasn't with you. That's what I'm telling you. Here's the thing. You're on deferred adjudication. I could send you to the state jail facility for 2 years. So what I need you to do for me is answer the questions that I'm asking and be honest. Because it appears that the state and the defense want to continue on probation. When you're on probation, this is a contract with the court. I do not have to follow any of their recommendations. So I'm trying to figure out what's going on with you. And if you're going to be dishonest with me, that means that there's nothing I can do to help you. And maybe 2 years is what you need to open your eyes. I was not with you when you were using drugs. I don't know what your idea or your definition of recreational use is. So now that we've said that out the way, I'm going to pretend like I'm just now meeting you and I've just sworn you in. So how often were you using?
During the week, like once a week. But
And what were you using?
weed, marijuana, and methamphetamine.
And when did you first start using meth?
2021.
And is all of your family in Beaumont or here?
Beaumont.
All right. All right, I'm going to give you a choice. I can continue you, but if I continue you, you're going to have certain conditions. You're going to remain in custody until a TAP evaluation is completed. You're going to follow all of those recommendations of TAP. And I'm going to give you some more conditions that I see that the previous judge did not give you. So, or I can revoke you and I will sentence you to 1 year in the state jail facility. What do you prefer?
Rather do first option.
All right. And probation, is that your recommendation?
Yes, Judge.
All right, the court will deny the motion. Alter and amend conditions. And I'm sorry, they're wanting a mental health evaluation. Have you ever had any mental health issues? Have you ever been on medication for mental health?
No.
All right, the court will deny the motion, alter and amend conditions. There's going to be a TAP evaluation in custody. That's to see what drug issues you have. It's basically a resume for your drug use. Yes.
Judge, in speaking with Ms. Kelly briefly, she did say that she was getting some medication for anxiety to help her sleep, and she's dealing with a bit of depression. I would like to get that mental health evaluation.
All right, there's to be a mental health evaluation in custody. There's going to be 120 sober meetings and 120 days upon release.
So
How far did you go in school?
I graduated with honors cum laude.
All right, is this college?
No, that was high school, and I did cosmetology.
All right, there's going to be 200 hours community service restitution. Those hours will be waived if you obtain some sort of trade school certificate or complete some higher level of education.
Massage therapy. That's my next venture.
Sorry, what?
Massage therapy.
Okay. And there's to be weekly reporting upon release. And proof of employment within 45 days of release, no employment as a home health care provider or with minors. And do a referral to felony drug court. And that will be in custody. Is there anything else that you need from the court to be successful?
Transportation assistance with bus fare.
All right, if you will talk to them, I know there are different organizations in the city that will give you a free bus token, but it's not forever. All right?
Yes.
Anything else that you need help with?
Some housing assistance.
All right, you'll need to talk to probation about that, but you need to be honest with felony drug court. If you're honest with felony drug court, they'll accept you into their program and they can help with certain needs you may have. All right, probation, is there anything else? All right, we can go off the record. In this court, to be successful on probation, communication is key. If there's an issue, let your probation officer know. If you feel they're not addressing it, you can always come back to the court. But one thing you should not do in this court is disappear. You understand? There is not a problem with picking up the phone and calling somebody to tell them what your issues are. You understand? All right,
Is
good
there
luck to
a person in particular that I would have a direct line?
They'll let you know it's your probation officer. All right, good luck to you.
Judge, you may be excused.
Yes.
All right, we have a few minutes left in our bonus half hour, so let's go back to Florida.
That's the agreement with the state?
Yes, Your Honor.
Tell me swear the testimony you're about to give is the truth, the whole truth, nothing but the truth, so help you God.
Yes, I do.
Mr. Humphrey, you can lower your hand, sir, and state your name.
My name is James Kent Humphrey.
Mr. Humphrey, you heard the announcement of Mr. Meredith. Is that correct?
Yes, sir.
Is that your understanding of the agreement with the state?
Yes, sir.
Has anybody promised you anything different?
No, sir.
Are you under the influence of any
No,
drugs or
sir.
alcohol today which would impair your ability to enter the agreement or understand any of the terms and conditions of it?
No, sir.
I've been handed a plea waiver of consent form. There's the front page. On the second page is a signature of the defendant line. Is that yours?
Yes, sir.
Have you had a chance to read that agreement?
Yes, sir, I have.
Have you had a chance to go over your case with Mr. Meredith?
Yes, sir, I have.
Have you had sufficient time to speak with Mr. Meredith about your cases?
Yes, sir.
Are you satisfied with your lawyer's advice and counsel?
I am.
You understand that by entering the plea, you're waiving your right to go to trial?
Yes, sir.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence.
Yes, sir.
You're waiving your right to present any defenses that you might have to the allegations.
Yes, sir.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf.
Yes, sir.
You're waiving your right to testify to remain silent at the trial, which would be a decision you'd have to make.
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence.
Yes, sir.
Are you doing this of your own free will?
Yes, sir.
Mr. Humphrey, do you feel the plea is in your best interest?
Yes, sir.
You understand if you're not a citizen of the United States, you may be subjecting yourself to deportation proceedings by entering the plea.
I understand.
I'll accept the stipulation. I'll find there's a prima facie case. I'm going to find that Mr. Humphrey's plea was freely and voluntarily made after consultation with his attorney. I'm going to accept it. In case number 25 CF 51, he's adjudicated guilty of aggravated assault with a deadly weapon. In case number 25 1396, he's adjudicated guilty of 3 counts of violation of no contact order and 1 count. And no, excuse me. In 1396, he's adjudicated guilty of a violation of court order. In case number 25 MM 546, he's adjudicated guilty of violation of no contact order. Case number 25 MM 84, he's adjudicated guilty of a violation of a no contact order. In case number 24 MM 6430, he's adjudicated guilty of a simple assault. On the aggravated assault, he's placed on a term of probation not to exceed 36 months. He's ordered to pay fines and costs of $1,028. There's no restitution applicable in the case. He must complete 100 hours of community service work at a minimum of 8 hours a month through the Bay County Work Program. I'll give the Florida Department of Corrections the discretion to amend that at the direction of the probation officer. His cost of supervision will be $20 a month. This is drug offender probation with the enhanced with the enhanced drug testing. He will not be subject to the curfew. He'll be subject to random UAs at his own expense with the direction of his probation officer. There'll be zero tolerance for any use of any controlled substance not prescribed by a treating physician. Department of Highway Safety Motor Vehicles may apply additional penalties. If he's required to give a DNA sample, he must provide one. Within the next 30 days, he must undergo a mental health evaluation, follow all recommended counseling, no contact with Rob B. Philhauer. He shall not possess or consume any alcoholic beverages while on release or out on probation. He must attend AA once a week throughout his probation. He must enter and successfully complete the batter's intervention program. He may only have peaceful contact with Shelley Rosa. On each of the misdemeanors, he's sentenced the time he served in the Bay County Jail, given credit for that time. All the sentences will run concurrent. Have I left off anything? No. Mr. Humphrey, you have 30 days to file your notice of appeal. If you wish to appeal the judgment sentence, if you'd like to have an attorney to represent you and you can't afford one, one may be appointed to represent you at no charge. Good luck to you, sir. You step over and be fingerprinted and speak to the probation officer.
Thank you, Your Honor.
Sir.
All right, and that brings us to the end of our day, dear friends. I hope you all had fun. I know I did. We'll be back tomorrow. I'm not exactly sure what tomorrow's going to bring. There'll probably be some courts that'll be off and extend their weekend, but I think some will be running because crime still happens and people have to be dealt with. So we'll see what tomorrow brings, but we'll be back 10 a.m. Eastern, 7 a.m. Pacific. If you are a channel member, join us a half an hour early for the pre-show. If you'd like to join us for the pre-show, there's a link in the pinned chat where you can click on that and become a channel member, and we'd love to have you be part of that. So again, go out and have a good day today. Make it a good Thursday. We'll be back tomorrow. And in the meantime, take care and God bless.